What's in Budget 2024? More infrastructure and less red tape so we can build more homes and build more affordable homes. A national school food program, serious investments in youth mental health, and contraceptives covered by a national pharmacare plan. We are driving productivity and creating good jobs by supercharging our innovation in AI. Bottom line, fairness for every generation.
I'm going to play this again.
Budget 2024, more infrastructure and less red tape so
Hold
we
on.
can build more homes.
Stop, please. Sorry, hold on. Am I in the right mic? I'm going to play this again. We're just going to I should make a little graph and just go bing, bing every time they mention a buzzword of verbal diarrhea. Hold on. Audio. No, we're in the good mic. Okay, hold on. Let's just go back. I don't know who we have to start with a palate cleansing laugh. This is Canadian government. I don't know who this woman is. We'll get her name in a second.
What's in Budget 2024? More infrastructure.
Bing! Infrastructure.
And less red tape.
Bing! Red tape.
You can build more homes.
Bing! Build more homes. 2024. The Liberals campaigned off that in 2015. Infrastructure, less red tape, build more homes. Bing, bing, bing.
And build more affordable homes.
Bing! Build more affordable homes. No, you should build some unaffordable homes. That makes a whole hell of a lot of sense.
A national school food program.
A national food school program because 1 out of 5 Canadian children is going hungry thanks to the Liberals' 8 years of power.
Serious investments in youth mental health.
Serious investments in youth mental health because the Liberal government has spent the last 4 years traumatizing adolescents.
And contraceptives.
Contraceptives, because the population is not growing. Promote abortion and contraceptions.
Covered by a national pharmacare plan. Oh. We are driving productivity and creating good jobs.
Creating good jobs.
By supercharging our innovation in AI.
Supercharging our innovation in AI. This is not parody. This is not a Saturday Night Live skit, although it's on par with the quality of SNL these days.
Bottom line, fairness.
Fairness? This is just diarrhea. This is just verbal diarrhea coming out of her mouth, and she looks crazy. I mean, it doesn't help that she looks crazy, although who am I to talk?
Every generation.
Oh, who is it? I know Rowan, the stallion, is the one who posted. Lisa Hefner, MP for Hamilton area, parliamentary secretary. Lisa Hefner, whatever. Oh my God, it's psychotic, delusional nonsense. Good morning, everybody. Feels like I haven't seen you in 12 hours. Hold on a second. I've got a tuft of hair. Why didn't anyone tell me about that? I got a dog on my lap. He's keeping me very warm. He got back from the place where they board dogs, and he got a little cut, and he smells so good. And then, hold on, let's just stare into the camera so people can see your eyes now. Hold on, just go like that. There you go. Okay, look at the dog. No, wait, this way. He looks so angry, like, pourquoi est-ce que vous m'avez fait ici? I am the Winston. I am king of the universe. Okay, down you go. Jesus, first of all, could you possibly STFU and let us listen without interrupting every word? No. Thank you for the input, however. You want to go watch that video without interruption? Go to Rowan the Stallion's Twitter feed and go listen to that verbal diarrhea uninterrupted, although I did play it uninterrupted before the thing got started. So yeah, thank you for the input, and I'm being tongue-in-cheek, as I presume you were, and if you were being serious, take yourself less seriously. Okay, today, hold on, I bit my lip on the inside yesterday, and it's still hurting, and now I keep biting it. I'm going to get in the backdrop the oral arguments thing so I can hear it when it comes up. It's oral argument in the obstruction, the contestation of the obstruction proceedings. The contestation of the obstruction charges brought against 330 of the January 6th defendants. It's going to be very interesting because we've been talking about this for a while. The obstruction charges, which were Enron era legislation charges that had to do with obstructing official proceedings via destruction of evidence, have been levied, applied against the January 6th defendants on the basis that they were obstructing Congress by protesting, or that by and through their protest, violent or not, however you want to call it, although I will not call it insurrection, and if you call it insurrection, you're an idiot. By and through their protest, they obstructed congressional proceedings, or they obstructed proceedings, and that's how they were broadly applying this provision of law. The oral arguments are here today. I got my footstool because my chair is elevated and I need to rest my feet on something. So the oral arguments are today. Sherry Super. I didn't know that the oral arguments were today. Well, I found out yesterday and I was like, well, we got to do this. So that's what's on the menu for SCOTUS today. And it's going to be interesting because we're going to hear presumably a lot of arguments or pleading about the history of the statute, because that's kind of relevant when interpreting a statute. Why was it enacted? Why is it drafted the way it is? Why does it say obstructions such as destruction of evidence, yada, yada, yada? And then it can include anything and everything like blocking someone's car from getting into their parking spot, obstruction of Congress. So that's what's going to happen at 10 o'clock, give or take. Now, I've got the thing in the backdrop here. Let me just bring it up so that I can see this. I want to share the screen for a couple more reasons because other stuff is going on. Okay. And other people out there, tell me if you know that this is on and I'm not bringing it up because I got it in the back. What was I going to say? So that's what that's going on today. I'll read an article just to summarize what is before the Supreme Court today. But there was something that someone brought up yesterday to my attention, that Jake Lang, the man who I interviewed a week and a half ago from prison, from jail in New York. Someone said, Viva, did you hear that Jake is back in solitary? And I was like, I hadn't heard that. And so I DM'd the Twitter account and got this. It said, yeah, we posted an update, and here's the update. And this is, take it for what it's worth, people. Everyone's entered the realm of doubt everything, believe nothing. And that's part of the information destruction, possible tactic being employed by the powers that be. But this is the update from Jake Lang, January 6th political prisoner, from his Twitter feed. Emergency update. The federal prison in Brooklyn, New York is committing retaliatory torture against Jake for exercising his First Amendment rights. We are extremely worried about Jake's safety and well-being. The Brooklyn Metropolitan Detention Center is absolutely horrific, disgusting, and should be demolished. I'm not going to bring those up. Example 1 and 2. Jake made his statements to his lawyers today. It is the first time we have heard from him in a week. So people were saying that this was a retaliatory action as a result of I'm not trying to be arrogant or anything. People were saying it's because it followed the interview that he gave with me. Apparently, I hadn't heard this, and I guess we hadn't heard it because if you go into solitary or you go into wherever the hell they throw you into this hole at this prison or jail, nobody's going to find out about it for a little while. So I didn't know this until now. This is what we heard from him the first time they've heard from him last week. This is from Jake. Quote, I am suffering by far the worst conditions I've ever been in. Worst conditions known to man. I've been held for a week without a change of clothes, without access to phone calls, without access to a towel, hygiene products, without access to a pencil or piece of paper to write a letter, and I'm stuck in a bleak, dirty, featureless dungeon-like cell 23 hours a day with a light in the cell that never turns off. The 1 hour a day I'm given to leave my cell through Monday through Friday is a 15 by 15 bird cage to stand in, which you are separated from other inmates and any human interaction. The environment I am in is so devoid of stimulation. The days and nights melt together. We don't have books. We don't have a radio. We don't have access to our family. We don't have what time it is. And the guards completely ignore every request of ours. This is hell on earth. I come to you not in the spirit of defeat, nor am I downtrodden by my enemies' attempt to break me. But these clear, evident human rights abuses at the hands of the Biden DOJ need to be exposed and immediately stopped. They have threatened to strip me naked and keep me in a cell in a painter's paper zip-up suit for asking for grievance paperwork, legal calls, and religious services. The diet they force upon you is wholly insufficient and leaves you starving every day before nightfall. We are served our last meal at 4 p.m. with 15 minutes to eat before they pound on our door to take our tray away. I am denied commissary, so I am left hungry for the rest of the day. Without the love of God, I would be in the most hopeless situation I could ever imagine any human being surviving under. Every semblance of human dignity has been stripped from me, including my most sacred right to speak freely to my loved ones, to the court, and to you, the people. The evil board of BOP is, I don't know what that stands for, but Bureau of penitentiary, and the DOJ are trying their hardest to make me disappear from humanity. I'll be survived if they don't kill me. Do not be in fear because God is still in control. Jake is in pretrial detainee. He's been stripped of his rights for refusing to be silent and refusing to be left to rot away. Please call MDC Brooklyn and demand Jake's release from solitary confinement. You got the number there, MDC Brooklyn, 718-840-4200. Please call your representative to bring attention to the travesties taking place. Edward Lang, inmate number 76480-054. So there's that. And here's the link to the tweet. Link to tweet. So that's what's happening with Jake. I'm refreshing the Supreme Court live oral argument to see when it comes up. Ooh. Why is it not playing? April 16, oral arguments. I'm refreshing. I press play. Okay. So let me just bring this up here. Make sure I'm not doing anything wrong. This is it. And what time is it? It's 10:06. Okay, we're going to try to get... I'll leave this here for a second. I've just refreshed it. So hopefully... Ah ouais donc. Joue. Okay, there's that. So my audio's fine. Anybody in the chat, if you hear it, let me know. And if I'm on the wrong channel, let me know. I'm going to take it out of the screen. So that's what's going on with Jake. Typical single man cell in a lockdown unit. If he did the interview in violation of regulations, this is what would have happened. I do not support him or January 6 people being in jail, but this is drama. Well, I disagree. I mean, Avenatti is giving jail cell interviews. When I did the interview with him, and my first question was, how the heck are you allowed to do interviews, podcasts? Because I'm by no means the first that he's ever done it with. And apparently, if you can buy a cell phone, you can buy access, you can do them. Avenatti gave an interview on MSNBC. Who's the guy that he gave the interview with? Ari something or other. So there's that. Now, before I'm sorry, I got ahead of myself. In fact, we didn't even double check that we're live across all platforms. We are live on Rumble. We are. Looks good. Hold on. Refresh. That's my face right there. No, hold on 1 second. Refresh. Okay. Est-ce qu'on est en direct de Rumble? Oui, je vois un avertissement. Non, pas un avertissement, une annonce, une publicité. Now I'm seeing an ad for a drone. Okay, good. We look like we're live on Rumble, and we are good. Are we live on vivabarneslaw.locals.com? We are. Bureau of Prisons, says Joe Maskew for BOP. The court is not live yet, says Dreary or Spider. That's in our vivabarneslaw.locals.com community. Okay, and while the court goes live, I'll just, while we have time right now and not to get too far behind, Crash Bandit says, how do these actions from our government not make people crazy? Or is this how the FBI performs a nudge? A little bit of A and a little bit of B. Some people do not get outraged, and this is how they nudge people into provoking responses that they can then use to warrant further egregious government overreach. Absolutely. Abraham P says, Lisa is heifer. And then Abraham P says, is the local stream, or is it just not loading or refreshing for me? Let me go. Locals looks like it's good. Yeah, we're good on locals. I see myself there. We got, they arrested Trump. They arrested Trump's lawyers. They arrested Trump's advisors. They arrested Trump's supporters. They arrested Trump's chief of staff. They arrested Trump's chief strategist. They arrested Trump's security advisor. That is a meme coming from Lying in State. And Zvi Hansis says locals working great. Okay, good. So now I'm going to take this out, bring back in the backdrop the SCOTUS live oral, and take it out. I'll just refresh. So this is what's happening today. I'm going to keep playing that in the backdrop. Okay. Let's read a little bit of article from how the MSNBC, the MSM News, is covering the story, and I will make my prediction before the hearing, and I will make my prediction after the hearing. This is from CBS News. Now, why am I bringing it up? Because they're filthy propagandists. I'm bringing it up because they're filthy propagandists, and when they have to cover something, and their reporting is almost favorable to what is my prediction as to how SCOTUS is going to rule, then you know that's how bad it is. So how are they reporting it? Supreme Court considers scope of federal obstruction law used to prosecute Trump and January 6 reporters. Washington. Supreme Court is set to weigh on the scope of a federal obstruction statute used to prosecute hundreds of people who breached the Capitol, yada, yada, yada. Legal ramifications that could have ramifications for election interference for Trump's case. Fine. At the crux of the fight, Fisher versus U.S. is the one who brought it. Whether federal prosecutors can apply a law passed in the wake of the Enron scandal to January 6 assault. That framing already leads me to believe that there's a big problem with how that statute's been applied. We know why it was applied in the context of Enron. The fact that they have to contextualize it with that unfavorable historical contextualizing leads me to believe that even MSM knows that this is a bridge too far and a load of crap. The measure makes it a crime to, quote, corruptly, end quote, obstruct or impede an official proceeding, and defense attorneys argue that the Justice Department has stretched the statute too far. Why? The first provision of the law prohibits altering, destroying, mutilating, or concealing a document, i.e. evidence. 23, we're hearing arguments. Here, boom, shakalak. Let's do this.
Mr. Chief Justice, and may it please the court.
Please the court.
Congress enacted 1512C in 2002 in the wake of the large-scale destruction of Enron's financial documents. The statute therefore prohibits the impairment of the integrity or availability
of evidence
of information and evidence to be used in a proceeding. In 2002, Congress hedged a little bit and added Section C2 to cover other forms of impairment, the known unknowns, so to speak. It was, after all, the dawn of the information age. Until the January 6th prosecutions, Section 1512C2, the otherwise provision, had never been used to prosecute anything other than evidence tampering.
Mm-hmm. The catch-all,
and that was for good
otherwise
reason.
impedes.
This court has said that otherwise, when used in a criminal statute, means to do similar conduct in a different way. The government would have you ignore all that or disregard all that and instead convert C2
into a
from
catch-all
provision into a dragnet.
Ooh,
One
like
of the things that dragnet would cover is Section C1. Our construction of the statute at least leaves C1 and C2 to do some independent work.
From catch-all to dragnet, that's good.
The January 6 prosecutions demonstrate that there are a host of felony and misdemeanor crimes that cover the alleged conduct.
Mm-hmm.
A Sarbanes-Oxley-based, Enron-driven evidence tampering statute is not one of them. I welcome the court's questions.
What? That's it?
Okay.
Okay.
Mr. Green, how do we determine what these two provisions have in common?
Sounds like Clarence
do we look
Thomas?
after the otherwise or before, and why?
You look at before, Justice Thomas, and you look at the kinds of manner in which documents and records are to be impaired, and then you look after to see what the effect is. But I would submit that the effect is the same, right?
It has to be evidence tampering.
Cause the impairment of the integrity of the evidence that's to be used in a proceeding or to prevent its availability. So we look back and we look forward.
Wouldn't it be just as easy to look at the C2 and then ask what it has in common with C1 and use C2's provisions as a basis for that similarity?
No, because in C2 speaks to the effect of the actions that the otherwise clause covers. So in other words, we look at C1 and we see that Congress is concerned about documents and records and other objects and things that are done to those to impair the integrity of those. And the effect of that is to obstruct. And so C2 omits that object and verb section.
But you could just as easily say that Congress is really concerned about things that obstruct, influence, or impede official proceedings. And that's C2. So why isn't that the basis for the similarity?
Well, because of the presence of the otherwise provision. So otherwise, as I mentioned, otherwise, this court has said, means to do similar conduct in a different way. So what we've got here is the impairment of evidence being done in a different way.
I'm sorry. I thought was, yes, doing it in a different way. So
Such
let
as
me give you an
preventing people
example.
from convening.
There is a sign on the theater.
Oh, here's
You
an
will be
example.
kicked out of the theater if you photograph or record the actors or otherwise disrupt the performance. If you start yelling, I think no one would question that you can be expected to be kicked out under this policy, even though yelling has nothing to do with photograph or recording. The object that the verb is looking at, the verbs are looking at, is the obstruction. It's not the manner in which you obstruct, it's the fact that you've obstructed. Isn't that the structure of this provision?
It is, Your Honor. It's in part the structure of the provision, but what your hypothetical
That was Kagan.
omits is that there is a specific retriculation, I guess it's called, of all of the different sorts of things that might be done to evidence to begin with.
Except
There's a
that
long-
what's fascinating about one, which is not about two, is that one doesn't require you to have actually impeded the proceeding. One requires you to have that intent, but you don't actually have to accomplish the intent. Two requires you to accomplish the intent. And so that's a very different articulation of what the object of two is. The object of two is the actual disruption of the proceeding.
Well, I would respectfully disagree because.
Well, why? Look at the language.
Well, let him
Alters,
answer that.
destroys, mutilates, or conceals a record. I do that in my home. And I do it anticipating that it might be needed. All I have to do is have the intent to impair. By that very language, I don't have to have an actual proceeding that I've impaired. On two, you need an actual proceeding to impair.
I guess I'm a little confused, Justice Sotomayor, because as I read this, I would think that the government would say that any attempt at one is also covered by the statute, and I'm not sure that I would disagree. So I don't think that there has to be an actual impairment.
No, I do think under one, you don't need an actual impairment. Under two, you do.
Well,
If you read it,
but
the
two
verb
says or
requires
attempts.
you to actually obstruct the proceeding in two. Nowhere in one do you actually have to obstruct.
Well, in two, you only have to attempt to do the things that are in
No,
two.
otherwise obstructs or impedes, or attempts to, yes.
Yes.
Counsel, can I ask you whether, let's imagine that we agree with you. On remand, do you agree that the government could take a shot at proving that your client actually did try to interfere with or under C1, or actually, no, I'm sorry, under C2, obstruct evidence because he was trying to obstruct the arrival of the certificates arriving to the vice president's desk for counting? So there would be an evidence impairment theory?
I'm quite sure that my friend would take a shot, Your Honor, but I would say no. And the reason why is that this statute prohibits operation on specific evidence in some way, shape, or form. Attempting to stop a vote count or something like that is a very different act.
He's
than
departing
actually
from the
changing a
historical
document or
purpose of
altering
the
a
act of
document
this
or
legislation.
creating a fake new
Well, he's
document.
obstructing evidence in my hypothetical. I mean, he's not actually altering the vote certificates, which is why I corrected myself and said under C2. I mean, would that be different than someone, say, in a trial or criminal proceeding trying to prevent evidence that was going to be introduced in the proceeding from making it there? So I'm imagining him acting on the certificates, not the act of counting.
Is this Amy Coney that
Yeah,
we're
I
listening
think they
to?
could try it, but I don't think that we're talking about trying to impair just anything other than the evidence itself. We're trying to obstruct a proceeding. And there's questions about what proceeding means here, as Your Honor doubtless knows. But what the government would essentially be doing, as you noted, is converting what they've charged in C2 to a C1 type of crime.
Well, no. C2, I mean, as I understand, maybe I'm misunderstanding your argument, but I thought your argument was that C2
Has to deal with
picks up
destruction,
other things, but they just have to be evidence related.
other means of destruction of
So in
evidence.
the hypothetical I'm giving you, it's evidence related because it's focused on the certificates, but it's obstruct or impede, say, the certificates arriving to the vice president's desk insofar as the goal is to shut down the proceeding and therefore interfere with the evidence reaching the vice president.
That's closer. It's definitely closer. But if you zoom out and look at all of 1512 in order to understand what kinds of impairment we're talking about.
Corruptly obstructing
we are
official
talking
proceedings.
about, or Congress is prohibiting the kinds of impairments that actually change documents that actually affect their integrity. If it's just impeding or delaying, we'd submit actually that is not part of 1512C. Delays are mentioned in 5 other parts of 1512, but not in C.
Mr. Green, if Justice Barrett is wrong, then what work is C2 doing? I mean, it seems like you've just now re-articulated
What
only
is
the theory of
C2 says
C1,
otherwise
and
obstructs, influences,
you're
or impedes
saying
any
that you
official
have to
proceeding.
make it into C1 in order to be, to have this statute apply. So can you help me at least understand under your theory what additional thing does C2 offer?
Let's look at the verbs of C1, which are alter, destroy, mutilate,
Mutilates,
and
conceal.
and let's think about their antonyms. So one, instead of destroy, would be actually to create. So one could use some sophisticated computer program.
this
We've
is an
heard
interesting
awful lot
argument.
about AI, and we've heard about the possibility of deep fake photographs. So I think you would violate C2 if you created a photograph that established your alibi in some extremely sophisticated
They're going to ask them why
way
would
that
C2
get
not
it
be
admitted into
incorporated in
evidence, or
C1
make it, or you submit it
if
for
it were
evidence
part and
would
parcel of
probably
the
be
same
where the
thing.
crime occurred.
So you're saying there are other things other than particularly altering, destroying, mutilating, or concealing, but it has to be limited to a record?
Not necessarily, because, I mean, one other example, if I might, Your Honor, would be not to conceal, but to disclose. So if I disclosed a witness list in a large multi-defendant drug trial,
That's a good
my
example.
purpose in doing that, though I haven't altered the document, would be to intimidate the witnesses or prevent their
And how about if you protest it
That,
on their front lawn?
Our submission would also violate.
Someone's
Can I
gonna-
just ask you one other question just so that I can fully understand your theory? You keep using the term evidence, and that does not appear in the statute. The statute C1.
It says record or
says
document. That's what he
record,
means.
document, or other object. Now, I appreciate that,
Historically,
evidence
that's
can be such a thing, but you can imagine a world in which those two are different. So where does evidence come in your theory, and why is it there?
Well, the title of the statute refers to tampering with witnesses, victims, and informants. But along with witnesses, victims, and informants comes evidence that they provide, whether in the form of testimony or whether in the form of
No,
documents.
I understand, but the statute, the provision we're talking about here does not use the term evidence. And so, and instead, or in addition, it uses the
Historical
term official
interpretation.
proceeding, which is elsewhere defined, not in terms of, court proceedings or investigations. It's just a proceeding, before Congress. So is it your argument that the only thing that this provision covers is something that is tantamount to evidence in an
record,
investigation, or
record,
trial?
document, or other object.
It is, Your Honor, and we're not limiting it. Our position does not limit it to documents or records. I would submit C1, which we say carries into C2 through the otherwise clause. When it
He's
says
having
other
problems.
object is pretty broad. And it need not be as 1512F provides. It need not be admissible. F. It need not be admissible. So it could cover things like electronic records. It could cover communications. It could cover emails. It could cover all kinds of things that we think get used by fact finders in a formally convened hearing.
I mean, just
What
to
about,
take you back to,
just a quick question. What about the Second Circuit's decision in U.S. versus Reich, where what was involved was not evidence, it was a forged court order? Would that fall within?
Oh, for sure.
C2?
That's a document.
Yes, we think that does fall within C2. And I think anything that is falsified in this operative way that is used to obstruct a proceeding would be covered by C2.
Thank you.
Yes.
And just to take you back to the question that Justice Thomas started you with,
Who's this?
it seems
This
to me
might be
there are two
Kagan.
choices here, and you could read this as otherwise obstructs a proceeding or otherwise spoils evidence. And you're using it to say otherwise spoils evidence,
And
with,
that
you know,
only.
spoils being all those verbs. But it doesn't say that. It says otherwise obstructs a proceeding. There are plenty of ways to write the statute that you want to write. You could just say
Otherwise
affects the integrity
obstructs,
or
influences, or
availability of
impedes
evidence in an
any
official
official
proceeding.
proceeding.
You could combine official proceeding with evidence in other ways. You know, one with you could replicate the mens rea that C1 has. I mean, there are ways in which C2, multiple ways in which the drafters of C2 could have made it clear that they intended C2 to also operate only in the sphere of evidence spoliation. But it doesn't do that. All it says is otherwise obstructs, influences, or impedes.
Certainly the statute could be written more precisely. Any statute could
That's
be written more
well,
precisely.
that might
Well,
be
it's
part
not
of
a
the
question
problem.
of precisely. The question is, what is this otherwise? This is what Justice Thomas said at the beginning. What is this otherwise taking from C1? Of course, there's commonality that's involved in an otherwise. There's both commonality and difference. But what is the commonality that C2 is drawing from C1? It tells you what the commonality is. The commonality is that the things that fall into C2 also have to obstruct, influence, or impede. But what C2 does not say, really does not say,
Is that it only
is
relates to documents.
everything in C2 also has to spoil evidence.
But this court has said that otherwise in a criminal statute means similar conduct.
Similar conduct.
I
obstruction
would
of a
have
proceeding,
one answer
different
to all of
ways
this.
of carrying out that similar conduct, which is obstruction of a proceeding.
Protest
The
is going to be
statute
obstruction.
tells you what the similar conduct is right on its face.
Go to the history of the
Respectfully,
legislation.
Justice Kagan, the statute tells you what the effect is. The conduct that's specified in C1 is altering, destroying, mutilating, or concealing a document or record or other object. And so a drafter of the statute could easily omit something like that and would omit something like that for the sake of economy and also to hedge, because we know that what comes before might not be exactly the same as after. So we're not going to repeat what we said there, but we're going to use a connector like otherwise to demonstrate that we're talking about similar conduct. And
But then
I would
why not
submit, Your
include it
Honor,
in
that
the
if you look
same
at C2
provision?
alone, that is, please.
What's your best case for this, like going backward and trying to find language that does not appear in the otherwise provision and trying to incorporate it into the otherwise provision?
Well, I think Begay is our best case for sure.
And that's not a
Gates is
very good
also-
advertisement, I would think. I mean, what Begay does is exactly that. So you have a very good case there. And it was a complete failure. You know, Begay said, we look back at this thing that Congress did not use in the otherwise provision, and we derive various things from it, and we put it in. It was purposeful, violent, and aggressive. And then a few years later, we said, where did that come from? We made it up, and we get rid of the whole thing. So that's not a great advertisement for rewriting a statute to take an otherwise provision that says what it says.
This is
and
not
turn
going
it
well
into
for
an
this
otherwise
lawyer.
provision that says something else.
We would submit that Begay was abrogated on other grounds, Your Honor. And the other grounds are the members of the court could not decide between an assessment of the types of things that came before otherwise versus the level of risk. And when that began to play out in complicated cases like Chambers and many others involving escape from a halfway house, it became and the court said, an untenable proposition to figure out what a potential harm to another person might be looking at what came before.
I don't understand what you just said there. That's
I'm sorry, Mr.
not good.
Mr. Green, go ahead, finish your sentence.
But that doesn't mean that the court's holding about how to construe a statute and its significant holding about otherwise was abrogated in and of itself as a result of the cases that came after Begay.
Well, I'm not a fan of Begay. Some of us perceived at that
Did he
time that
just say-
there were problems, different problems with what the court did there. But I think there's a point in the colloquy that you've been having. The specific types of conduct that are enumerated in one: alter, destroy, mutilate, conceal a record, document,
Or
etc.,
otherwise, like had it been one provision, how would they
two
read
things
it?
in common. One, they all involve documents or objects, and they also all involve the impairment of the object's integrity or availability for use in an official proceeding. So the similarity could be either of those things. And so I think that you may be biting off more than you can chew by suggesting, if you are indeed suggesting, that the otherwise clause
Only
can
relates
only
to
be read
documents.
the way you read it. One might say it can certainly be read the way the government reads it, and that might even be the more straightforward reading. But it is also possible to read a clause like this
Why hasn't he gotten into the
more narrowly,
history
and Judge
of the
Katz has
provision?
provided an example of that in his opinion. If you had a statute that says anyone who kills or injures or assaults someone or otherwise causes serious injury, commits a crime, you wouldn't think that that applies to defamation. So it could be read your way. So then I think you have to go on to some other arguments and explain why your reading is better than the government's reading.
Because it's part and parcel of the
Certainly,
same provision
I
and
would submit, Your
historical
Honor, that
interpretation.
there are plenty of other reasons why
Such as?
our reading is the better reason. And I'm
Such
not going to
as?
contest or bite up more than I can chew and say that the government's reading of C2 is implausible. We think it's unsound, but it's unsound for the additional reasons that if one zooms out and looks at what the prohibited conduct is in 1512 generally, we are talking about interference or operation on forms of evidence and testimony that obstruct a proceeding. That's what 12 is all about generally. And I would submit, Your Honor, too, that as the briefing indicates, Jus Gem Generis and Nocitero Socius, those two venerated Latin canons, also operate in our favor here, as well as the broader context of Chapter 73 and Section 15. All of these things are about doing things that
The title of the section is Tampering with a Witness, Victim, or an Informant.
1512 and 1512C zero in on witnesses and evidence.
Well, you have other arguments. You have surplusage arguments. You have arguments about the breadth of the government's reading of the provision. Do you want to say anything about those?
Well, this guy's helping them out
Right.
because the lawyer's not helping
So,
himself here.
With respect to surplusage, Your Honor, I would refer to Judge Katz's opinion, as you did, in particular in the joint appendix at page 88, which lists out all of the different provisions in section 1512. 15 of the 21 would be subsumed by the government's reading of C2. The government's reading of C2, I remind the court, is so broad that it would cover anyone who does something understanding that what they're doing is wrong in some way, that in any way influences, impedes, or obstructs an official proceeding of any type.
Has he not mentioned
Well,
the
Mr.
word
Green, I mean,
Enron yet?
Limited by federal.
There's a good case that this provision, everybody knew it was going to be superfluous because it was a provision that was meant to function as a backstop. It was a later enacted provision. Congress had all these statutes all over the place.
Yeah,
It
and
had
this was
just
a- this
gone
was a
through
dragnet.
Enron. What Enron convinced them of
Here you go.
was that there were
Other
gaps
ways
in these
to destroy
statutes, and
evidence.
they tried to fill the gaps. They tried to fill the particular gap that they found out about in Enron. And then they said, you know, this is a lesson to us. There are probably other gaps in this statute. But they didn't know exactly what those gaps were.
Exactly.
So they said, let's have a backstop provision. And this is their backstop provision. And of course, in that circumstance, I mean, superfluity is very often a good argument when it comes to statutory interpretation. But it's not a good argument when Congress is specifically devising a backstop provision to fill gaps that might
Backstop,
exist. They
fill
don't
gap,
exactly
catch-all,
know how they exist,
dragnet,
but
stay
they
it.
think that they probably do exist.
Which judge is this
in
again?
a pre-existing statutory scheme. And that's what this provision is intended
Is
to
this
do.
Sotomayor or Kagan?
Respectfully, Your Honor, a close reading of Yates,
Kagan,
both the
okay.
majority opinion and the dissenting opinion, demonstrates that this court thought that 1519 was the backstop. That was supposed to be the omnibus provision. And the court was fighting over what the meaning of tangible object was in 1519. But that was meant to plug the hole that
Counsel,
Congress.
I have such a hard time with the superfluidity argument because this entire
Oh, I hate
obstruction
this. I hate
section
this
is
voice. Okay.
superfluidity. There isn't one provision you can point to. You just said it. You can point to 1512 and you have 1519, which says destruction of evidence. How
What?
are they different? They're really not. You can point to any series, any provision,
This one's
and
Sotomayor.
point to superfluidity
think.
in this section, 1512 and otherwise. So we go back to Justice Kagan's position, which is what you don't have is a freestanding, otherwise obstructs, influence, or impedes any official proceeding. I don't see why that's not the backstop that Congress would have.
The backstop is
intended, and it's the
anything.
language it used.
A
Well,
tweet.
it's an awfully odd place to put it, isn't it? I mean, in a subsection of a subsection in the middle back of the statute to include a provision
Well,
Oy.
I mean,
that suddenly takes
but
over
there's
15
nothing
of the
about
21 other provisions.
You're
the
not
one
supposed to
thing
fight
that
with the
Justice
judges.
Kagan pointed to, which is clear, they wanted to cover every base. And they didn't do it in a logical way, but they managed to cover every base.
No, I
Every
think you
base.
can reconcile. I mean, again, that's what the court said about 1519 in Yates. And I don't understand how it is that the government can come before you today and say we need yet another catch-all, yet another omnibus crime.
Because
that
that's
will
how they
sweep in all
drafted
kinds
it.
of other. We didn't get what we wanted in section 15. So now we'll go to 1512C2 and see if we can expand
Exactly.
that in this way to cover something that it has never covered before.
Thank
And
you. Thank you, Counsel. Justice Thomas, Justice Alito, Justice
Man, this is-
Sotomayor.
We've never had a situation before
Oh, like this
where
insurrection.
there's been
Insurrection.
a situation like this with people attempting to stop a proceeding.
Oh, really?
violently.
Kavanaugh hearings? Dummy?
So I'm not sure
Didn't
what
have
lack
that.
of history proves.
Oh, she an
I'm-
idiot.
I'm
I'm
not sure
sorry.
that that's true. I'd point to the Hatfield courthouse problems in Portland, Oregon, but
Point to
let's-
Kavanaugh
let's also
hearings.
look at what the court has
Obstruction.
said in so many different
Holy
cases.
cows.
in-
It's easy
in
to think on your feet when
Dubin,
you're not there, people. But
in Bond, in Yates, in Kelly, all of these
But
cases.
there was a difference in the use of words. Here, otherwise obstructs, influences, or impede. You might have a problem with breadth, and the government can address that. But it's not unclear what those words mean.
But the government has no way to address its problem with breadth.
Well,
Because-
we
well,
can
now
let
he's
them
changing his
answer.
argument.
Justice Kagan, Justice Kavanaugh.
That didn't go
If
well.
it were just the language in C2 and so said, whoever corruptly obstructs, influences, or impedes, C2 without the word otherwise, that were the whole provision, do you acknowledge that the language would then be applied properly to a situation like this?
Unfortunately, no. And the reason for that is that, again, applying all the other canons and applying the whole text canon and zooming out and looking at 1512, we would submit that C2 should still be read in the way we have suggested that it be read, as something that is an evidence impairment statute.
Or-
I think
or a
also,
witness
as I
tampering
mentioned,
statute.
the Latin canons, the surplusage problem that C2 would create, all of those would still obtain if it sat there by itself without the otherwise. The otherwise is the icing on the cake. And finally, Justice Kavanaugh, I would mention that, as I mentioned to Justice Barrett, there's
Let
an
me
issue.
just, if you didn't have C1, just had C2 without the otherwise, I'm not sure I was clear on that.
Oh, okay. Well, in that case, I think it gets even harder, but I would still say if we look at what 1512 is about, and if we look at this court's cases on broad, plausible, but broad readings of criminal statutes.
Well, he's got
not
two
being
arguments.
what the court adopts when there's an
Overbreadth,
available narrow
overbroad
reading, because
versus
Congress can
misapplied.
fix
Let me write that down.
We would still say that C2 doesn't perform the massive dragnet function that the government submits.
Thank you.
Two different arguments there, and it's confounding them.
Yeah, I have a question about the phrase in
About-
C1, the specific intent. Do you agree it's specific intent with the intent to impair the object's integrity? Okay. What is your view about how that parenthetical applies to C2, if at all?
Parenthetical.
Do you think that that intent requirement carries over?
The corruptly intent requirement?
Not corruptly, with the
This
intent
is
to
Amy
impair the
Coney, I
object's
believe, as well.
integrity or availability for use in an official proceeding.
Yes, we do, Your Honor.
So it carries over.
And we say that's the object of the overarching mens rea.
But how can that be? I mean, it seems like that, C2 would read awfully oddly then. It would be otherwise obstructs, influences, or impedes any official proceeding with the intent to impair the object's integrity or availability for use in an official proceeding. That would be your position of how it would read?
Well, I think that's right. I mean, it's awkward. I mean, there's no doubt that it's an awkward statute, but if you do the operation that I talked about earlier, which is we're just going to use otherwise to replace the verbs and the nouns in C1, then the statute.
His retort should be, what use is C1 if C2 is a catch-all?
Which is that
why
this
even put
intent
C1 in?
is a specific form of intent. The corruptly, which has been construed to be the mens rea up there, is not different than, at least on this reading, or on the accepted reading it by the DC Circuit right now, is not different than some form of specific intent.
So corruptly is redundant?
It seems like it's getting to be, yes.
Okay.
That's
thank
true.
you.
And our submission is that corruptly should mean something different. So should proceeding. That's how you marry 1512 with 1519.
Justice Jackson.
So I'm just still wondering if your theory about this provision might be too narrow in a sense, because you've got evidence going and spoliation in a sense.
Okay,
What
so far-
I'm trying to work out in my mind is whether you would still have a decent argument if this 1512 language is read to prohibit the corrupt tampering with things that are used to conduct an official proceeding with the intent of undermining the integrity of the thing or access to the thing, and thereby
So I
obstructing the proceeding.
didn't understand a
Not
word you just said.
evidence,
You had
it's
me.
an official
You
proceeding.
lost me.
C1 is an example of, the corrupt tampering with certain things, and C2 broadens
everything.
it out a bit. It's
Broadens
not
out a
just
bit
documents
to
and records.
everything.
What do you think about that?
Well, I think that's a correct reading, Your Honor. I mean, as 1512 F demonstrates, it doesn't, 1512F we would submit actually supports our position, because it says the evidence need not be admissible or free of a privilege claim. Now, what would that mean about what the statute is addressing if it's not evidence? But that C2 has been applied, and occasionally C1 has been applied.
In a non-evidentiary way.
Yeah, to things that could become evidence, to the efforts to shape someone's.
This is all too
grand jury
confusing, and if it's too
testimony.
confusing,
All right,
it's
let me
lost.
Answers to interrogatory.
Let me ask you about the question that Justice Barrett asked before. You suggested that it has to be to the document, but in other
Related
words,
to.
the activity has to be actually to the document. But I don't know why that's the case under C2. Justice Alito says, well, one of the commonalities between C1 and C2 could be the impairment of the object's integrity or availability. Justice Barrett posits a scenario in which you have someone who is impairing the availability by doing something to prevent the object from getting to the proceeding. Why wouldn't that count under C2? So this is preventing Congress from counting the electoral votes, for example.
What
Let's say it's
purpose
being done.
would
She says it's in an
C1
envelope
function
going to the
if C2 means what they
Vice
say it
President's
means?
desk, and someone does something to impair or
Mic drop.
prevent that from happening? Why isn't that what C2 could cover?
Well, first, it's not affecting the integrity of the document, Your Honor, or the
Availability is also in the statute.
Availability, it says too, but as I mentioned earlier, simply delaying the arrival of evidence at the
No,
courthouse.
not delay. Let's say the person steals the envelope and takes it away.
Then it gets harder. I agree. They steal the envelopes, they take it away, they rip up all of those
That's
things. which is
destruction. That's
certainly
quite
not
clearly.
what happened here, and it's not in the indictment. The ballots or the vote count is not even in the indictment.
But we wouldn't have to decide that. We could
Right.
send it back if we clarified that that is what the statute means. I'm trying to understand if you agree that that's what the statute could mean.
No, I don't agree that that's what the statute.
Why not?
The reason is that if you look at 1512, it is about a direct effect, or in some senses, an indirect effect, but in a limited way, on evidence that's to be used in a proceeding, right? And proceeding, as I mentioned earlier.
So as to limit its availability. So what
So
I'm
as to limit its
suggesting
availability.
is in C2, if you're doing
Oh,
something to
jeez.
limit it, to limit its availability, why doesn't it count?
Because we're limiting the availability of its use by a fact finder in a proceeding. Again, that's the way to marry 1519, which covers all kinds of investigations and all kinds of other events, with 1512. 1512 is talking
I can
about
hear
evidence that's
Barnes
going
yelling
to
at
a
this guy
formal
now.
convocation,
Drop bombs,
some
lawyer.
kind of hearing.
You want to criminalize
before
what they did for
Congress or
Kavanaugh?
before any other
You want to
body.
criminalize what they
Thank you,
did for in
Thank you.
Tennessee?
Thank you, counsel.
Thank you.
Not good. That did not go well. Channeling Will Ferrell here. How'd that go?
Mr. Chief Justice, and may it please the court.
Please.
On January 6,
Insurrection.
2021, a violent mob stormed the United States Capitol and disrupted the peaceful
Preach
transition
it.
of power.
Sing to the choir, woman.
Many crimes occurred that day, but in plain English, the fundamental wrong committed by many of the rioters, including petitioner,
Was
a
protesting.
deliberate attempt to stop the joint session of Congress from certifying the results of
That's
the
a,
election.
that's a lie, but doesn't
That
matter.
is, they obstructed Congress's work in that official proceeding. The government accordingly charged
Sounds like
petitioner
an
with
AI
violating
robot.
Section 1512C2, an obstruction offense that directly reads onto his conduct. The case as it comes to this court presents a straightforward question of statutory interpretation. Did petitioner obstruct, influence, or impede the joint session of Congress? The answer is
Congress.
equally straightforward. Yes,
answer is
he
yes.
obstructed that official proceeding. The terms of the statute unambiguously encompass his conduct.
Unambiguously.
Petitioner
Because
doesn't
it captures
really
everything.
argue that his actions fall outside the plain meaning of what it is to obstruct. Instead, he asked this court to impose an atextual limit on the actus reus. In his view, because Section 1512C1 covers tampering with documents and other physical evidence, the separate prohibition in Section 1512C2
Must also
should be
apply to
limited to
document.
acts of evidence impairment.
Mhm.
But that limit has no basis in the text or tools of construction. His reading hinges on the word otherwise, but that word means in a different manner, not in the same manner. And the two prohibitions in Section 1512C2 aren't unified items on a list where you could apply associated words canons. They're separate provisions. They have their own sets of verbs and their own nouns. They each independently prohibit attempts, which would be duplication that makes no sense on petitioner's reading.
Vocal fries drive
And
me
Congress
crazy.
included a distinct mental state requirement in C1 that it chose not to repeat in C2.
Because C2 is supposed to be
Section
in conjunction with.
1512C2, by its terms, is not limited to evidence impairment.
Mhm.
Instead, it's a classic catch-all.
Catch-all.
C1
Dragnet.
covers specified acts that obstruct an official proceeding, and C2 covers all other acts that obstruct an official proceeding in a different manner. The court should say so and allow this case to proceed to trial. I welcome the court's question.
Well, that was
General,
already better.
There have been many violent protests that have interfered.
There you
with,
go, Thomas.
Proceedings. Has the government
Ever done this?
applied this provision to other protests?
No,
in the
because the head was
past?
never
And
so
has this
bad.
been the government's position throughout the lifespan of the statute?
Thomas
It
is
has
the
certainly been the government's position since the enactment of 1512C2 that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you?
With-
so
has
you-
it ever been
have you
applied
enforced it
to
in
another
that manner?
protest?
We have enforced it in a variety of prosecutions that don't focus
Answer
on evidence
the
tampering.
question.
Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding.
Oh, like Kavanaugh
specified one
hearings?
from occurring with all of the elements like intent to obstruct, knowledge of the proceeding, having the corruptly mens rea, but that's just because I'm not aware of that circumstance
Because it's
ever
never been
happening
done.
prior to
It's, yeah,
January
it's never
6th.
been done.
But just to give you a flavor of some of the other
Flavor Flav.
circumstances where we have prosecuted under this provision,
Let's hear it.
for example, there are situations where we've brought C2 charges because someone tipped off the subject of an investigation
That's
to the
witness
grand
tampering?
jury's hearings. There was another case where someone tipped off about the identity of an undercover law enforcement officer. And in
Obviously
those situations,
different.
there's no specific evidence, no concrete testimony or physical evidence that the conduct is interfering with. Instead, it's more general obstruction.
By the way,
of the
did you get
proceeding.
convictions in those
Justice Alito
cases?
mentioned the Wright case as well, and that's another one where it was a forged court order that prompted the
Quite
litigant to
different.
dismiss a mandamus petition.
Quite
But that
different.
didn't have anything to do with the evidence that was going to be considered in that
Oh,
proceeding.
forged court.
So what
Great.
role does C1 play in your analysis?
So we understand 1512C to split up the world of obstructive conduct of an official proceeding into the C1 offense and into
to
C2.
everything else.
C1 covers everything it enumerates. It's the acts of
Mhm. And
altering,
C2
concealing,
covers
destroying
everything.
records, documents, or other objects. And then C2 would only pick up conduct that obstructs an
Would
official
only-
proceeding in a
it would
different
only
way.
pick
So
up
there's no
conduct of
duplication
everything
or
else.
superfluity on our reading. Instead, Congress was taking this universe and dividing it up into the two separate offenses. And I think that's actually a virtue of our reading as compared to petitioners, because I have not heard him articulate anything that would fall within C1 that wouldn't also come within C2. So on his reading, C2 really does just swallow C1 whole.
Well, I mean, in the way you're reading
On your reading, it does.
C1, C2 almost exists in isolation, certainly not affected by C1.
We don't deny at all that there is a relationship between the two provisions,
Oh,
Justice
thanks.
Thomas.
We
What
don't
is that
deny it.
relationship?
And the relationship is the one Congress specified in the text. It's what follows the word otherwise. That is the relevant degree of similarity. What both C1 and C2 have in common is that they or aim at conduct that obstructs an official proceeding. C1 does so in one way, tampering with records and documents. C2 does so with respect to all other conduct that in a different manner does that. And I think that this has to be the road the court goes down to look at what Congress actually prescribed with respect to similarity. Because in contrast, if you take up petitioner's invitation to come up with some atextual gloss from C1 to port over into C2, I don't understand what the court could look at to guide its determination of exactly what the relevant similarity would be.
General, I'm sure you've had a chance to read our opinion released Friday in the Boysonet case. It was unanimous. It was very short.
I didn't read it. What did it say?
But it explained how to apply the doctrine of justum generis. And what it said is that specific terms, a more general catch-all, if you will, term at the end. And it said that the general phrase is controlled and defined by reference to the terms that precede it. The otherwise phrase is more general, and the terms that precede it are alters, destroys, mutilates, and seals a record and document. And applying the doctrine as was set forth in that opinion, the specific terms alters, destroy, and mutilate carry forward into 2, and the terms record, document, or other object carry forward into 2 as well. And it seems to me that they, as I said, sort of control and defined the more general term.
So, Mr. Chief Justice, I think that the
And I'm sorry, just to interrupt, so I
yes.
put out exactly what, and the otherwise means in other ways. It alters, destroys, and mutilates record, document, or other objects that impede the investigation, and otherwise, in other ways, accomplishes the same result.
So I think the problem with that approach with respect to 1512 is that it doesn't look like the typical kind of statutory phrase that consists of a parallel list of nouns or a parallel list of verbs where the court has applied a justum generis or the Noscator canon. These are separate prohibitions that have their own complex, non-parallel internal structure. And I think actually the best evidence that it's hard to figure out how you would define a degree of similarity between them just based on the word otherwise is that there are multiple competing interpretations at issue in this case. Justice Alito touched on them, and they're reflected in the competing interpretations between Judge Katsas on the DC Circuit and Judge Nichols on the District Court.
Competing interpretations of what?
So, and it relates to exactly the question you asked me, which is that Judge Nichols thought that C1 should limit to C2, and he looked at it and said, well, the relevant thing about C1 is it deals with records, documents, and other objects. And so that means C2 should be limited only to other acts that impair physical evidence. Meanwhile, Judge Katsas looked at the specific intent requirement in C1 to take action that impairs the availability or use of the evidence, and he divined a broader gloss to put on C2 and said it should be other impairment of all other evidence.
Well, they're just applying the same doctrine to different aspects of it. And I think you do that as well. What are the common elements? Alters, destroy, and mutilates
Yep.
a
Or
record
otherwise.
document.
Or otherwise.
You have the first few, what you're doing and what you're doing it to. And
what you're
apply
doing it
both of
for.
those as it said in Boisonette, controlling and defining the term that follows, so that it should involve something that's capable of alteration, destruction, and mutilation, and with respect to a record or a document. That's how
So I actually don't even understand.
When you apply that doctrine, again, as we did on Friday,
Let her answer that.
it responds to some of the concerns that have been raised about how broad C2 is. You can't just tack it on and say, look at it
Everything.
as if it's standing alone, because
Absolutely.
it's not.
Well, and if
So
it
let me
did,
respond to that
it
in two
covers
ways. I
everything.
do want to have a chance to address any concerns about breadth, but the more fundamental point, I think, is that I don't even understand petitioner to be suggesting that you can mix and match the verbs and the nouns from C1 and C2 in this way. Judge Nichols had a more limited view that C2 exclusively focuses on physical objects. It wouldn't apply to things like testimony because of the limitation that he gleaned from C1. Judge Katsas, I think, maybe in line with your question, would interpret it more broadly. And the basic point as a textual matter is that there is nothing in the text of C2 itself to disclose what the relevant similarity from C1 ought to be. Instead, we think the relevant similarity is obstruction of an official proceeding because that's the language Congress chose.
General, if that's the case,
See,
what
the more
work
she
does
talks,
authorized do
she
on your
digs a hole.
theory? Because I think I might, as I'm hearing you, think that whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so stands alone. And the otherwise, I'm not hearing what work it does. Can you explain to me what work it does on your view?
Yes.
It's
so
a
the work that
catch-all.
otherwise does is to set up the relationship between C1 and C2 and make clear that C2 does not cover the conduct that's encompassed by C1. Now, I acknowledge that there would have been
Beyond saying, okay, C1 does some things, and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view?
Yes, but there was a good reason for Congress to do it this way.
No, I
and it traces to
understand.
the
I just-
statutory history.
I understand
and
that.
I would just say that
if I might, so what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify?
There you go.
At the State of the Union address? Would pulling a fire alarm before a vote
Jamal Bowman
qualify for 20 years in federal prison?
Yes.
There are multiple elements of the statute
Answer
that I
it.
think might not be satisfied by those hypotheticals. And it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512C2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means
Bullshit.
that if you have
That's
some
a terrible
minor
response.
disruption or delay or some minimal outburst,
Okay,
we don't
so
think it
the
falls
protester
within the
does it
outburst
with
outbursts
the
require the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
Good question.
So with some of them, it would be necessary to show nexus. So with respect to the protest outside,
shut
of course,
up,
we'd have to
Weasel.
show, yes, they
I
were
think
Weasel.
Weasel.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We
And
went around that
particularly-
tree yesterday.
I know. I heard the argument yesterday.
Went around
but
the tree. That
I guess
sounds
what I
like
would say
peed
is
on
to
the
the extent
tree.
that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of
So
those
mostly
protesters had
peaceful
corrupt intent.
protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent. And that's a
Oh,
high
no,
bar. We argue-
they intend to do it, all right.
Yes, if they intend to obstruct and we're able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes, that's a 1512C2 offense.
Oh, there you
And
go. She said it.
Corruptly add,
Protest.
in your view.
By the way, for everyone asking
corruptly
what
adds the
C1 and
requirement
C2
that
is,
the
here's
defendant's
the link.
conduct be wrongful and committed with consciousness of wrongdoing. And this traces to the court's decision in Arthur Anderson, where the court said this is a term
Mr.
with deep
Anderson.
historical roots with a settled meaning, and that it connotes not just knowledge of your actions, which is, the intent to obstruct in this case, but further requires that it be done corruptly. And just to give you a more concrete example of how this has played out in the January 6 prosecutions, I'd point to the jury instruction in the Robertson case, which we refer to and quote in part on page 44 of our brief. There, the jury was instructed that in order to show the defendant acted corruptly, the jury had to conclude that he had an unlawful purpose or used unlawful means or both, and that he had consciousness of wrongdoing. So I think that that is an encapsulation of what the jury is asked to decide on top of the mere intent to obstruct.
General, let me give you a specific example, which picks up but provides a little bit more detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests.
Sounds like Roberts.
Let's say that today,
Kavanaugh.
while
Kavanaugh.
you're arguing or Mr. Green is arguing, 5 people get up one after the other and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots.
Well, did they
And as a
have
result
corrupt
of this,
intent?
Our police officers have to remove them forcibly from the courtroom. And let's say we have to, it delays the proceeding for
20 years.
5 minutes.
Right to jail.
And I know that experienced advocates like you and Mr. Green are not going to be flustered by that. But, in another case, an advocate
It's Alito.
might
Okay.
lose his or her train of thought and not provide the best argument. So would that be a violation of 1512
Yes.
C2?
Did they have the
I
corrupt
think it would
intent?
be difficult for the government to prove that.
Why?
At the outset, we don't think that 1512C2 picks up minimal, de minimis, minor interferences. We think that the term obstruct on its face connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes. Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot. And
Well,
impedes
the
is also
hell
not
does
a
that
means
mean?
for
Meaning you're preaching the plain
Iteration.
meaning
Foot.
interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is to retard in progress or action by
Retard.
putting obstacles
He's
in the
canceled.
way. So it doesn't require
Of course not.
obstruction. It requires the causing of delay.
And if this
So
court,
again, why wouldn't that fall within, now you could say, well, we're not going to prosecute that.
Yeah, that would be
And
the
indeed,
selective
for all the
prosecution.
protests that have occurred in this court, the Justice Department has
Never.
not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But
Well,
why isn't that a
what's his
violation
face?
of 512,
Infowars.
1512C2?
we read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well,
and
that's
in the
not a
concept
corrupt
of
intent. It's wrongful. Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say
Oh,
that they
I'm
weren't
sorry.
conscious of
You think the
fact that they weren't
defendants in
allowed to
January
make that
6th
kind
don't
of
say
free
that?
protest in the court. And I think it's in a
Oh,
fundamentally different
pounce on
posture
her,
than if they had
judges.
stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and
Oh,
done so with
shut
clear
up.
evidence
Yes,
of intent
indeed,
to obstruct.
absolutely. What happened on January 6th was very, very serious, and I'm not equating this with that. But we need to find out what are the outer reaches of this statute. under
Given your interpretation.
Let me give you another example. Yesterday, protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco. What if something similar to that happened all around the Capitol, so that all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there. Would that be a violation of this provision?
It sounds to
depends.
me
I'd
like
have
that
to
wouldn't satisfy the proceeding element nor the nexus
Why
requirement.
would it
And
not?
nexus,
Why
would
not?
it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
well,
They
if
wanna
we had
get to the
clear, if we had
Capitol.
clear evidence that the purpose of the protesters who had set up the blockage
Was to slow them
somewhere,
down.
some distance
Then
away
yes.
from the court was because they had a specific proceeding in mind, maybe you have the proceeding, but still the court has required a nexus. And that's been the requirement in
The
cases
nexus.
like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work because you have to show that the natural and probable effect of the action is to
They
obstruct.
block
There has
in the
to be
bridge
both
to
a
prevent them
relationship
from
and
getting
time,
there.
causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute 7212, that use this exact same formulation that the court has characterized as an omnibus clause and never suggested could be subject to an evidence gloss. So I don't think that to the extent you have concerns about those hypotheticals, your question about what would happen in this courtroom could be covered by 1503. And interpreting this
Well,
statute
let me-
narrowly isn't going to cure
Let me
that
give
issue.
you one more example. An attorney is sanctioned under Rule 11 of the Federal Rules of Civil Procedure by filing pleadings, written motions, or other papers for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. And in a particular case, the judge imposes Rule 11 sanctions and says, this caused a lot of trouble. I can tell you it caused at least 5 work days for me personally, all of this unnecessary paper. And it delayed the progress of this litigation. So I'm imposing Rule 11 sanctions. Why doesn't that fall within your interpretation of this provision?
Congress created a specific safe harbor in 1515C. It's reprinted at page 17A to the appendix of our brief that specifies that advocacy or legal representation that is conducted as part of a proceeding shouldn't be understood as obstruction. So I think Congress was itself
Unless
trying to
you're
draw some
Trump's
lines
lawyer, by the
around
way.
participation in a proceeding on the one hand versus external forces that obstruct the
It
proceeding
falls
on the
within,
other
but
hand.
it falls within the language, doesn't it?
What kind of evidence do you typically present in these January 6th cases to prove the corruptly element?
So the January 6 prosecutions require us to show first that the defendants had knowledge that Congress was meeting in the joint session on that day. We have to show that the defendants specifically intended to disrupt the joint proceeding. And then with respect to using unlawful means with consciousness of wrongdoing, we have focused on things like the defendants' threats of violence, willingness to use violence here. We allege that petitioner assaulted a police officer. We have focused on things like preparation for violence, bringing tactical gear or paramilitary equipment to the Capitol. And I want to emphasize, Justice Kagan, that this is a stringent mens rea requirement that has very much constrained the U.S. Attorney's Office. We've charged over 1,350 defendants with crimes committed on January 6th.
Bit of a
But
problem.
we've only had the evidence of intent to bring charges against 350 for a 1512
So how do you make
violation.
that
Bull
decision? How
crap.
do you decide which defendants get charged?
Yeah, what
under
about
this
Ray Epps?
statute
Who's
as
gonna ask
opposed
that?
to not?
The dividing line has hinged usually on the evidence we have of intent. So we're looking for clear evidence that the defendant knew about the proceedings that were happening in the joint session in Congress that day, clear knowledge of the official proceeding. We've looked for evidence that the defendant specifically intended to prevent Congress from certifying the vote, and so used his actions to obstruct that proceeding. And then also, as I'd mentioned, the knowledge of wrongfulness or unlawful conduct can come about with respect to particular preparations that the defendants have made. And, you know, there are a number of cases where even though we thought we had the evidence beyond a reasonable doubt, there have been acquittals because there was, you know, testimony that was credited that the defendant thought the proceedings were over and wasn't intending to obstruct. Or one person thought and said he thought that law enforcement was waving him into the building. So even in situations where we think we have amassed the evidence, we still haven't always been able to sustain these convictions, and it's because of the stringent mens rea.
Oh,
General,
bullshit.
can I ask you about
Sorry.
your obstruction theory? Because you said that you see 1512C as dividing the world of an obstruction, and that the nexus between 1 and 2 is the official proceeding and the obstruction of an official proceeding. I guess what I'm concerned about is how you then account for the rest of 1512, where official proceeding comes up over and over again, and particular acts that one
By the way,
could
Ketanji
view
Brown
as
Jackson doesn't
obstructing
want
the
this
official
interpretation
proceeding,
either.
like
So
killing or
probably
threatening
more
or
on our
intimidating
side than you
witnesses
think.
is covered. So that if we read C2 to be obstructing an official proceeding, I don't understand what happens to the rest of those provisions.
So to the extent you're pressing on the idea that there's surplusage, I don't think that that's true. There is certainly overlap or duplication. That's
Well,
true on
that's a
both of the readings
surplus.
in this
That's a
case.
surplus,
I think
young
in
lady.
part it might even be more true on petitioner's reading because he says that C2 is likewise focused on all of the evidence impairment ways to obstruct, interfering with testimony, interfering with documents, and so forth. And so that very same duplication is going to be present on his reading. But with respect to superfluity, our interpretation doesn't create any technical superfluity, and that's because each of those other provisions that you cited, and in fact, each of the other provisions of the obstruction laws cover situations that 1512C2 wouldn't cover. There are three principal distinctions. The first is that some of them have less than a corruptly mens rea. So for many of the provisions, they can be violated in ways that wouldn't require the government to prove corruptly, and it might mean that we could charge particular applications of those provisions under them and not under C2. The second thing is that some of the provisions sweep more broadly than an official proceeding. They apply in a wider range of circumstances. So that would enable us to charge in those situations where we can't actually prove the official proceeding element. And then third and finally, some of the provisions have a higher penalty specifically because they target more culpable conduct. And that's like 1512A, the one you referenced about killing a witness. There, the government would charge under that provision because it's subject to higher penalties than C2.
All right,
So
well,
there's no actual
can I ask you,
superfluity.
would the government necessarily lose in the sense that they would not be able to bring charges against some of the people that you have described with Justice Kagan if we looked at C2 as being more limited, perhaps not all the way to evidence, but related to conduct that prevents or obstructs an official proceeding insofar as it is directed to preventing access to information or documents or records or things that the official
We'll
proceeding
talk
would
a lot
use.
more when
I
they're
explored with
done.
Mr. Green and as did Justice Barrett, the idea that to the extent that there were people who knew that the votes were being counted that day, and that's done in a documentary way in our system, they're interfering by storming the Capitol might qualify under even an evidence or document interpretation of C2. What does the government think about that?
Yes, I think that if the court articulated the standard that way, these would likely be viable charges. And as we note in the last footnote of our brief, we've preserved an argument that we could satisfy even an evidence-related understanding of C2, in part because the very point of the conduct when we have the intent evidence was to prevent Congress from being able to count the votes, from being able to actually certify the results of the election. Now, we'd obviously need to evaluate whether these charges can go forward based on whatever this court says, and I would very much caution the court away from any holding that would require specific evidence by the government of, precise electoral certificates or that kind of thing. Here, the point of it would be that those who came to the Capitol and engaged in this criminal conduct to displace Congress violently from where it had to be to count those votes acted with an intent to impair Congress's ability to consider that evidence.
General, the district court and the dissent below had a different variation on the statute and how to read it. You were starting to explain that to the chief. Could you do it if we accepted the district court's view? I presume that you could do it if we accepted the dissent below, correct?
Yes.
Yeah,
So
but your whole response to Justice Ketanji, to Justice Jackson, sorry, to Justice Jackson is that it assumes the dissent's view.
I thought that Justice Jackson was potentially proposing even a broader view, including
No, she
focusing on the
wasn't.
availability part and making clear that when the whole point is to prevent the proceeding, including the consideration of evidence in the proceeding from happening, that could qualify.
Okay.
I think it becomes potentially harder on the Judge Katz's view and especially harder on the Judge Nichols' view. And that's precisely because Judge Nichols seemed to think that to prove obstruction, it had to be limited to taking action with respect to the documents themselves. And that would be a difficult standard for us to satisfy.
You read our discussion on corruptly yesterday. It's clear. You've endorsed the Robertson view. Could you tell me what you feel about the Walker view? Judge Walker being the part of the majority below. I assume you know that, but.
Yes. So Judge Walker articulated an idea that corruptly has to turn exclusively on the government being able to show that the defendant sought to secure an unlawful advantage for himself or someone else. We certainly agree that that's one way for the government to prove corrupt intent. It's a way that has traditionally been deployed in the tax context because the very theory of the case is that the defendant is violating the tax laws or taking efforts to secure an unlawful advantage under the tax laws. But I think that it would be incorrect for the court to suggest that that's the exclusive mechanism for the government to try to prove corruptly. You know, there are various other ways where we might have evidence of, as we think we do here, unlawful means committed with consciousness of wrongdoing, and there's no basis in the common law or in how the term corruptly has long been understood to limit the government's ability to prove it only with that one specific way that Judge Walker pointed to.
The draw in this case appears to be the fear that reading the government's view of either yesterday's case or today on its plain terms would make it so broad that somehow that presents a problem. I think the judges below struggled with that by saying that gets addressed in the word corruptly and in the nexus requirement, which is the point you made today. But neither of those two issues were resolved below because that wasn't the question below, correct?
That's right. The only issue that the DC Circuit resolved was the meaning of the actus reus.
And the only issue between us is whether we read the words, how we read these words.
That's right. But I don't want to lose sight of the fact, as your question touched on, that there are inherent constraints built into the other elements of the statute. The nexus constraint is a really critical one. It is the paradigmatic constraint the court has pointed to ensure that obstruction statutes don't sweep too broadly and scoop up everyday conduct that might be happening out in the world. It has to have that tight connection, the relationship in time, causation, or logic with the official proceeding. And of course, corruptly, we think sets a very high bar, as evidenced by the fact, as I said to Justice Kagan, it's not like we can even prove it with respect to everyone who was in the riot at the Capitol on January 6th.
Thank you.
Only the 303,
General,
330.
Are you putting a violence requirement as an overlay on obstruct,
No,
influence, impede?
absolutely
And
not.
I'm thinking of some of your answers to Justice Alito's hypotheticals. It seemed like you
No,
kept
corruptly,
emphasizing
not
the
violence.
aspect of violence that was present on January 6th. So am I understanding you to say there has to be some sort of violence or no?
No, we
No.
don't think that's a requirement under the statute. I think it will clearly be easier for us to satisfy things like the corruptly mens rea when we can point to action here, like assaulting a police officer that is obviously wrongful, unlawful conduct, and everyone knows that that's a crime and you cannot do that.
Yeah, but
What I was trying to say to Justice Alito is in situations where hypotheticals press on the idea that people are engaging in conduct that maybe they think is constitutionally protected, they might be wrong about that. There might not be a First Amendment right that they think they have, but that can demonstrate that they don't have the requisite consciousness of wrongdoing. That would mean we couldn't prove an obstruction charge.
Thank you, counsel.
Yep.
I'm not quite sure I understood the answer you gave earlier about whether or not you've previously used C2 in this type of case. Have you done that before or not?
We've never had one
C2
like
in situations that don't involve evidence impairment, and the litigating position of the department has long been that, as its plain language suggests, it covers myriad ways of obstructing. I'm not aware of any other factual circumstance or event out in the world where we could have proved all of the elements of Section 1512 C2 beyond the cases where we've brought those prosecutions. So,
And just so I understand, the prosecutions are limited in what way?
they're limited to a requirement that the specific people had in mind an official proceeding. So that would take out the category of hypotheticals where, you know, maybe you're protesting a branch of government, you're outside this court, but you don't have this specific argument in mind. And then we would also need to show an intent to obstruct the proceeding and the nexus to the proceeding. And that can take care of, you know, situations where maybe someone's pulling a fire alarm in a different building, but it's not even where the proceeding happens.
In prior cases, you have applied C2 in a situation, not involving specific documents?
Correct. So things like tipping off someone to the existence of a grand jury investigation,
Witness,
or the identity of an undercover officer, or creating a fake court order that has nothing to do with
forgery,
the evidence in the case.
witness
Just
tampering.
prompting
Very
the litigant
different,
to dismiss a pending mandamus petition.
And your friend points to an Office of Legal Counsel opinion from 2019 that I haven't looked at it yet, but I will. It says it is consistent with Judge Katz's opinion below.
So that advice that was offered to the Attorney General and never adopted as a formal position of the Department of Justice related to distinct issues that arose out of the special counsel investigation and distinct issues that involved the office of the presidency. I don't think that it would be right to suggest that the memo took any firm stand, although it did suggest that maybe 1512C2 should be understood more narrowly, but it certainly didn't represent any formal adoption of that position, and that would have been inconsistent with how the government has always litigated under C2.
What constitutes a formal acceptance of OLC opinions?
I should probably know the
Nothing.
answer to that
Nothing.
one as a
Yeah, I
matter
should
of
too, but-
DOJ policy. But what I can tell you is the reason I'm saying that wasn't an official position is because it specifically said
They're
there's no
they're
need
never
to go
official
down the road of
positions.
even deciding exactly what
It's an
1512C2
opinion.
covers, because even assuming that it covers the full range of obstructive conduct, the allegations, according to the memo, didn't satisfy the standards there. So it ultimately just punted on the issue and said it's not necessary to engage with that issue further.
Thank you. Justice Thomas?
General, you said, as I understand it, that you have applied C2 in previous cases.
That's right. We've applied it in cases that do not fit the evidence impairment model that petitioner is
What she
urging on the
described, though,
court
does
here.
fit the
And
evidence
it's not just
impairment.
C2, Justice Thomas, but it's the omnibus clauses of 1503, 1505, 7212. These are statutes that use the exact same verb
Those
phrase.
are fine, but C2.
Yes.
I'm not clear as to whether or not the specific instances in which you have used C2, because you seem to think that argue that C2 is a standalone provision almost.
We think that it covers the full range of obstructive conduct that's not covered by C1.
But then
of course,
why
limited by the
have
requirement of an
C1?
official proceeding.
Why have
So
C1?
if you have applied C2, have there been previous, other than the DC Circuit, previous courts of appeals that have looked at this?
Yes, and the uniform consensus among the Court of Appeals has been that C2 is not limited by this kind of evidence impairment gloss that petitioner is asking the court to read into the statute. There has been no Court of Appeals that's gone the other way. We cite a string side of them that have recognized, looking at the plain language of this provision, that it sweeps in the myriad forms of obstructive conduct.
So much of your argument seems to hinge on this being fairly clear, your interpretation of C2.
Yes, we certainly think we have the best of the plain text.
Okay, if I happen to think it's more ambiguous, what would your argument be?
So what I would say is I think that if you look at the terms in the statute themselves, that the plain language of the statute supports our view, but it doesn't end there. And I have mentioned several times the other provisions in 1503, 1505, but we think that's actually really relevant because Congress wasn't writing on a blank slate when it enacted 1512C2. It's not like it just thought of for the first time this verb phrase obstructs, influences, or impedes. That wasn't taken out of the ether. That was a well-established term, verb phrase, and obstruction law drawn from those other statutes. And as this court has said many times, when Congress takes a phrase like that, it brings the old soil with it. And so Congress would have clearly known that the courts, this court and lower courts, had interpreted the omnibus clause in those other statutes to encompass the full range of obstructive conduct. That's also consistent with all precedent, as I mentioned to you earlier. So I think when you put it all together, there's no real ambiguity here. We clearly have the best reading. And the only other thing, the icing on the cake, if I could, is that if actually what Congress wanted to do is write a statute that focused only on evidence impairment, there was a really clear and obvious way to do it. Congress could have just tacked on a residual clause to C1 that says or otherwise impairs evidence. It would not have used this oblique reference of otherwise and then used a term that had a well-settled meaning in obstruction law to sweep more broadly to try to convey that type of limited scope. It would just be nonsensical for Congress to draft that way because it would be so readily misunderstood. And in fact, every lower court has understood Congress to have legislated more broadly here.
But that's beginning to sound more like a contextual argument, which you seem to eschew in this case.
Well, no, I think actually that the statutory context and history does bear weight here. And we think that the roots of this language and those other obstruction provisions help fortify or reinforce how the court has always understood the plain language.
Justice Alito?
You argue that there's an exception for conduct that has only a minimal effect on official proceedings. Where does that come from in the text?
That comes from the verb phrase obstruct, influence, or impede, which we think, if you look at dictionary definitions, conveys the type of action that blocks, hinders, makes difficult, persistently interferes with. This is the kind of, the verbs themselves we think inherently contain this limitation.
There can't be a minor impediment?
I think as a colloquial matter, yes, maybe, but we think that if you look at what Congress was trying to do as a whole, the lead term here is obstruct. These were various ways of trying to capture the world of obstructive conduct, and I think that that adequately conveys the idea that some kind of very minimal de minimis interference doesn't qualify.
So it didn't stop with obstruct, it added impede. But what is the meaning of, how would you define a minimal interference? I suppose a jury would have to be charged on that in order to prove that the person violated this provision. You must find that the person committed more than caused.
Yeah, so like what they did with Kavanaugh, that was de minimis.
How would you define it?
Getting in the elevator,
I think,
de minimis.
to the extent that this would come up in actual prosecutions, and I'm not aware of any, but if this came up, then I think that it would be the defense theory. It's possible that the court could decide it as a matter of law if in fact it was so minimal it doesn't fit within the statutory terms themselves. And I recognize that maybe there could be gray areas about the nature of the obstruction and whether it really satisfies the actus reus.
AI lawyer.
I think that is properly a subject
what about
for
the
the jury.
example I gave you about the 5 protesters in the courtroom? Is that minimal?
Owen Schroyer.
I think that sounds minimal to me. I mean, it sounds to me like if it hasn't actually forced any substantial halt to these proceedings, it seems like that
Substantial.
wouldn't pick up and
They
track,
counted
but,
the votes by that
the same issue
afternoon.
would arise under 1503, which likewise refers to obstruct, influence, or impede.
You haven't said anything about the surplusage arguments. Let me just ask you a question or two about that.
Good.
Suppose someone commits conduct that falls squarely within 1512D. The person intentionally harasses another person and therefore dissuades that person from attending or testifying in an official proceeding. So you've got a clear violation of 1512D, punishable by no more than 3 years in prison. But when Congress added 1512C2, which seems to cover exactly that conduct, it said, well, the punishment shouldn't be, you could punish that person for up to 20 years.
There's a key difference between 1512D and 1512C in that D doesn't require the intent to obstruct. And so the effect of the defendant's harassment action is to prevent the testimony or the production of the document, but the government has not read that statute to require an actual intent to obstruct, which I think means there are certain factual scenarios where the government might be able to prove a 1512D offense without satisfying C2. But I do want to be responsive to the broader concern that there's something anomalous about the 20-year penalty here. Let me say at the outset that no matter which statute the government charges under, with respect to all of the relevant obstruction statutes here, they would be funneled through the same sentencing guideline. So the charging decision wouldn't make a difference with respect to the sentencing range. And the concern you have with the hypothetical arises equally on petitioner's reading, because so too, everything that would be covered in 1512D falls within his evidence impairment limitation. So I don't think the existence of a statutory max when there's no mandatory minimum should drive intuitions about how to interpret this provision.
Well, I'm not sure that's the correct interpretation of subsection D1. How about 1512B, which also has a 20-year penalty, but it seems to be completely subsumed by C2.
I think there is a lot of overlap between B and C. I don't deny that. Again, that would be true on either reading because B is paradigmatic witness tampering. So even on petitioner's understanding of the statute, there would be equal duplication there. What I would say is there's no actual superfluity because there are ways of violating B that wouldn't fall within our understanding of C2, including acting in a misleading manner towards someone, which wouldn't necessarily satisfy a corrupt intent definition.
Really? You think you could knowingly threaten?
Mislead, she said. Mislead.
Corruptly persuade, corruptly mislead someone? I don't understand that argument.
So my recollection is that there are multiple different means of carrying out that offense. Of course, something like threatening or corruptly persuading.
How about a meme? How about a meme?
Referring to earlier, but another way you can violate B is through intentionally misleading someone. That wouldn't necessarily require corrupt intent.
Douglas Mackey's going to jail for 20. Have we had enough here? I've had enough. Any more questions?
Okay, thank you. Sorry, one more question. I was struck by the contrast between your argument here that the court should read in a minimal exception with the argument that you made earlier this term in
Ooh, this is going to be good.
Muldrow versus the city of St. Louis, where the question was whether an adverse employment action has to be significant or not. And you said, no, it doesn't have to be significant because, quote, the text likewise admits of no distinction between discrimination that results in a significant or insignificant disadvantage.
This is interesting.
In Muldrow, you told us, no, don't read in an atextual requirement of significance, but here
But
you
here
seem
you're
to be
telling us you have
arguing,
to.
yes, you've got to read in an atextual requirement of something that's more than minimal.
No, that is not our argument here. We are grounding this in the text. So we're not suggesting that there's a basic de
well,
minimis principle that applies
tell us
throughout
where the
all
words
the
that you
various
used are
legal
in the text.
statutes that are out there. Not anything like that. Instead, we ground this in a particular understanding of what it means to obstruct and what that word conveys.
Thank you.
Justice Sotomayor?
I know the Risch case because I decided it.
Oh, it's good for
However,
you.
the tip cases, are they in your briefs?
We cite Ahrensfeld. That's the case where a subject of a grand jury investigation was tipped off about the existence of the investigation, but there was no, kind of material impact or clear evidence of impairment of the evidence or availability of testimony or physical documents. And there are a number of cases in that line, including, I don't think we specifically cited, but it includes the disclosing the identity of an undercover officer.
Where do I find those?
We would be happy to supply additional citations if you're looking for them. I believe that the DC Circuit decision as well cited a range of C2 cases and made clear that they didn't cover evidence impairment.
Thank you.
Justice Kagan?
Mr. Green referred a few times to 1519 and basically said, well, that's supposed to be the catch-all provision, the omnibus provision. Why are you asking 1512 to do the same thing that 1519 is supposed to do?
Good question.
So that's one question I have for you. And the other question I have is just, you've referred a number of times to other omnibus provisions, 1503, 1505. What's the tax one?
7212, 26 USC 7212.
If we go down Mr. Green's road in terms of importing other limits from other places in the statute, are any of those likely to be challenged in the same kind of way, or are they written sufficiently differently so that we wouldn't have to worry about that?
So let me take the questions in order. With respect to petitioner's reliance on 1519 as the catch-all here, I understood the court's decision in Yates to say precisely the opposite. In fact, Yates drew a direct comparison between 1519 on the one hand, which it said was a more narrow obstruction provision based on some of the contextual clues there, and 1512C1 on the other hand, which has the phrase record, document, or other object, and said, well, that's the broad obstruction provision. That's the one that's intended to be codified in this broader prohibition that's aimed at official proceedings. And that C1 language is actually quite broader and would scoop up the entire world of physical objects, in contrast to the narrowing interpretation the court accepted in Yates. So I don't think the idea that 1519 was the broad catch-all can in any way be squared with what that statute says or how this court interpreted it in Yates. And instead, I think that the example to draw from Yates, or the lesson to learn from it, is that this court recognized that Congress was plugging the specific hole in the Enron scandal, and it did so with overlapping provisions, 1512C1 and 1519, but it was 1512 that the court pointed to as the place where you would sensibly locate this broader provision that aims at the full range of obstructive acts to catch the known unknowns. With respect to the question, I'm sorry, now I'm forgetting the second question, about the other statutes and whether they would be endangered. I would be concerned about that. I'm sure defendants would try to make arguments. The language, the verb phrase is exactly the same, or in different order sometimes, but it's obstructs, influences, or impedes. And so the relevant verbs in the actus reus would be similar. There are different direct objects there. For example, in 1503, it's the due administration of justice. In 1505, it's the administration of the power of Congress's inquiry and investigation. But it's not clear to me whether defendants might seek to try to now artificially limit those clauses beyond their plain terms, even though these kinds of provisions have been in the obstruction law. I think it traces all the way back to 1830, and they've never been understood to have that kind of narrow limitation to evidence impairment or anything else.
Thank you.
Ms. Gorsuch, Justice Kavanaugh?
I think the key word in that is otherwise, and
That
trying
is
to
the
figure
key
out
word.
what that means
That's what
under
it
our
hinges
established
on.
principles of statutory interpretation. It would seem to trigger a justum generis under the Begay precedent. And you've used the phrase a few times, catch-all provision, as does your
Dragnet.
brief.
Use
And
dragnet.
Scalia Garner book describes justum generis as how you interpret catch-all provisions. Does justum generis apply here or not?
No, we don't think it can sensibly apply here. So the court has said many times that otherwise is a natural way for Congress to create a broad catch-all category. And I certainly don't dispute that there can be situations where you have a parallel list of nouns or a parallel list of verbs where the court might further think that justum generis principles apply. But that's just not how 1512C is structured. It has, as I've mentioned, its own complex internal structure. You know, you've got the mens rea requirement that's unique to C1, and Congress did not transplant that into C2. That triggers the other canon that when Congress uses disparate language in two adjacent provisions, usually it means something by that. So I think that this just isn't the kind of situation where the court could sensibly apply justum generis. And the other thing I would say is that, you know, if the court goes down the road of trying to glean some kind of requirement from C1, the other reason the canon is inapplicable here is that it's not evident on its face what the common attribute would be. And that just relates to the Nichols-Katsas dispute.
As you know, that's true in almost every justum generis case, and the treatise explains that as well, which is it's hard sometimes to figure out what the common link among the words in the phrase is. So I don't think that point distinguishes this case from other justum generis cases, but you can respond to that.
But I do think that a plain speaker of English would recognize that usually the common link or the connective tissue is the language that follows the word otherwise. That's the congressionally approved similarity. That's what C1 and C2 have in common. They both relate to obstructing an official proceeding. And, you know, I recognize that petitioner has invoked Begay. Your question touched on it, but the statute in Begay, which we think is not the model of statutory interpretation to follow here, the statute itself was relevantly different. It had a list of nouns, and so it was the kind of statute where potentially a justum generis could apply.
What about the contextual points, a couple of them that I think have come up, but I just want to make sure you have a chance to respond, that it would be odd to have such a broad provision tucked in and connected by the word otherwise.
I don't think that the placement in the statute is odd at all for a couple of different reasons. One is the point I was trying to make to Justice Kagan about this court's own recognition that 1512 is one of the big obstruction statutes. This is the statute that is aimed generally at official proceedings. It's not more discrete, and there are other provisions like 1519 and some of the ones that come right before it that are more narrowly confined and are intended to reflect discrete circumstances. That doesn't describe 1512 at all. So when Congress was trying to broadly prohibit obstruction of official proceedings, 1512 was exactly the right place to go. Then petitioner says, well, Congress buried it in the middle of the statute. But I think it's actually quite explicable when you look at how the other provisions are structured. 1512D, which I was discussing with Justice Alito, has a much more minimal penalty and doesn't require the intent to obstruct. So it made sense to put 1512C before it, but also after 1512A, which is the most serious obstruction, like killing a witness, punishable by 30 years or up to life.
Last question. There's 6 other counts in the indictment here, which include civil disorder, physical contact with the victim, assault, entering and remaining in a restricted building, disorderly and disruptive conduct, disorderly conduct in the Capitol building. And why aren't those 6 counts good enough, just from the Justice Department's perspective, given that they don't have any of the hurdles?
Because those counts don't fully reflect the culpability of petitioner's conduct on January 6th. Those counts do
This
not
is all
require
specific
that
to
petitioner
January
have acted
6th.
corruptly to obstruct an official proceeding. And obviously, petitioner committed other crimes that we've charged and that we're seeking to hold him accountable for. But one of the distinct strands of harm, one of the root problems with petitioner's conduct is that he knew about that proceeding. He had said in advance of January 6th that he was prepared to storm the Capitol, prepared to use violence. He wanted wanted to intimidate Congress. He said they can't vote if they can't breathe. And then he went to the Capitol on January 6th with that intent in mind and took action, including assaulting a law enforcement officer that did impede the ability of the officers to regain
And
control of
charge
the
him with
Capitol and let
assault,
Congress
not
finish its work in that
obstruction under that
session.
provision.
And I think it is entirely appropriate for the government to seek to hold petitioner accountable for that conduct.
Then
with that
charge him
intent.
for
The
assault.
sentences, the sentence available is longer for this count than for any of the other counts or all of them together?
The statutory maximum is higher, but after a recent decision in the DC Circuit, which held that a particular sentencing enhancement doesn't apply, that was the Brock case, I believe the sentencing range, the guidelines range for the assault count would actually be a higher guidelines range. And just to give you a sense for a typical
There you have your
January
answer.
6th defendant, someone who doesn't have a prior criminal history and who committed violent conduct at the Capitol, accepting responsibility, I think the average guidelines range or the range that would yield is 10 to 16 months of
If they
imprisonment.
plead.
For someone who didn't commit violence, it would be 6 to 12 months of imprisonment.
Can you
We look at
imagine
the
that?
average
She's,
sentences here, there are
this
about
this
50 that have
Itchbay
gone
is saying
to
this in front of the Supreme
conviction and
Court.
sentencing on just a 1512C2 is the only felony. So I think that's the best way to gauge it. This was when the sentencing
6
enhancement
to
did
12
apply.
months
So
for
the ranges were
nonviolent.
higher. The average sentence among the approximately 50 people is 26 months of imprisonment, and the median has been 24 months. So there's
She
no
should be in jail.
reasonable argument to be made that the statutory maximum here is driving anything with respect to sentencing.
Thank you.
2 years.
General, I want to ask a clarifying question about the distinction in the government's charging decisions between C1 and C2. Actually, let me make that stronger, not charging decisions, like what you could charge under the statute. So as you pointed out to Justice Kavanaugh just now, C1 has this additional mens rea requirement, but, there is overlap. If you read otherwise obstructs, influences, et cetera, broadly, it would encompass, frankly, even on the other reading, it would encompass things like alters, destroys, mutilates, et cetera. But you wouldn't have to prove the extra mens rea. I thought I heard you say, and I just want to clarify to Justice Jackson earlier in the argument, that the government could not charge an alteration, mutilation, concealing a document or physical object under C2. Am I?
That's correct. We usually charge the specific paragraph. And so if the conduct fits within C1, we would charge it under C1, and that would be the proper place to locate the charge.
And is that charging, is that prosecutorial discretion, or do you think the statute would permit you to charge it under C2, thereby escaping the specific intent requirement?
Well, let me say that there is a specific intent requirement under C2. So there's no distinction
But it's
between them in that
different than
regard.
the
Right.
one
It's the
that-
intent to obstruct the official proceeding. So you're right that we wouldn't have to prove intent to, mutilate a document or something, but we would still have to show the intent to obstruct the proceeding. This is pressing on, honestly, what's a difficult question about means versus elements. And I think the best reading of the statute is that these are different elements because they have these different actus rei, they have the different mens rea requirement, the mens rea requirement that's specific to C1. They each independently prohibit attempts, but it's a hard question ultimately. And if we charged under the wrong paragraph,
And it gives us a broad,
accidentally, I think we could usually
a broad
say
discretion.
that was harmless error or else recharge under the correct paragraph.
We have our
Okay, let me
choice.
ask you a question that kind of gets at some of the same points that Justice Alito's questions were getting at. So what if on January 6th, the Capitol itself had not been breached? The protest is going on outside the Capitol. Stop the steal, stop the steal. Police are, in megaphones saying disperse, disperse. They're too close to the Capitol. Their goal is to impair, impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
Yes.
So I think that one relevant question would be
I
whether
personally
we could
believe
satisfy the nexus requirement and show that
US
actually the
Americans-
natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and in the
so
mind
you
run.
can. You can.
Yes. So if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we had, for example, organizers where it was absolutely clear that they were the ringleaders who had intended to obstruct and undertook the action with that specific intent and did so knowing it was wrongful, and especially if they went, I'm assuming you're saying they're in the unauthorized area right outside the Capitol, that is unlawful conduct committed with consciousness of wrongdoing if we have the proof of it.
Let's say that I am having a hard time seeing,
getting a little
accepting
tedious.
your limiting construction of the verbs obstruct, influence, or impedes to have this extra element. tell me why I shouldn't be concerned about the breadth of the government's reading, just relying on
Oh, because we'll
corruptly
only
and the
use it
nexus
property.
requirement? Should
right?
I be concerned, or could you just
No.
embrace it and say, yeah, there might be some as applied First Amendment challenges or that sort of thing? I mean, can I be comfortable with the breadth if that's what I think?
Of course you
Yes,
can, because
be.
we
Certainly
are
don't
good
have to agree
people.
with us that a de minimis hindrance wouldn't qualify. If you thought that this was unqualified and swept broadly to any kind of hindrance whatsoever, there would still be really important limits in the statute.
Oh,
Obviously, you'd have
limits
to have
on,
the
yeah,
official
they got
proceeding.
limits.
I think the nexus requirement could be somewhat harder to establish in a circumstance where you might not think that the natural and probable effect of the conduct is going to be to obstruct the proceeding. You'd have to show that the defendant knew that the natural and probable effect would do that. You'd still have to show the corruptly mens rea. And as you mentioned, even if you could show all of that, if it were a circumstance that really did infringe on First Amendment rights, there would always be the backstop of an as-applied constitutional challenge.
Do you think it's plausible that Congress would have written a statute that broadly? I mean, let's say that I think that Justice Alito's example of the protesters in the courtroom,
Is a good example.
Let's say it's corrupt and it impedes the proceeding because we have to go off the bench and things are stopped. Let's say I think that that's covered by the word impedes, and there's the nexus and it's corruptly.
Then you've
Is it
criminalized
plausible
protest.
to think Congress wrote a statute that would sweep that in?
Yes, I think that there are a lot of legitimate ways to try to voice
She's
your
asking the
dissent if you disagree
executioner
with what the court is
if
doing.
she has the
but
right to
one
kill.
of the ways you cannot do it is come into this courtroom, halt the proceedings, force the justices to leave the bench, and do it with the intent and the corrupt mens rea. I think that Congress could think that is a severe intrusion on the functioning of our government and want to protect against that. And again, the 20-year statutory
she's
max,
saying
of
it out
course,
loud.
is just a max. There's no
It's just a
mandatory
max.
minimum. So Congress would have recognized that sentencing courts would use their discretion to tailor the actual sentence to the facts of that specific
Oh, yeah.
offense.
Thank you.
Justice Jackson?
So you've emphasized several times that Congress wasn't writing on a blank slate in 1512C, but do you dispute that it was writing against the backdrop of a real world context? It was in the wake of Enron. There was document destruction.
Not a terrible question so far.
There was nothing, as far as I can tell, in the enactment history as it was recorded that suggests that Congress was thinking about obstruction more generally. They had this particular problem, and it was destruction of information that could have otherwise been used in an official proceeding.
This is the best question of the day.
Can you just give us a little bit more?
Reassure
as to
us.
why we shouldn't think of this as being a narrower set of circumstances
Reassure
to which
me
this text relates.
that you're not going to use
Sure.
it
And,
against my
I'd start by
cause.
saying that we, of course, acknowledge that the immediate
That was the
impetus
best
for adding
question so far.
1512 to the statute was to close the Enron loophole. It was a glaring loophole in the coverage of the obstruction laws that it wasn't a crime for you personally to destroy the document, and the government had to charge people for instead persuading other people to destroy documents. So that was front of mind for Congress, and Congress wanted to address it. It did address it with C1 and with 1519 separately.
And
But I think the
C2.
best way to look at what Congress was doing in light of that context is to consider the fact that Congress went further and enacted C2. The broader lesson Congress took away from Enron is that when you set out in advance to try to enumerate all the various ways that official proceedings can be obstructed,
can't.
things will slip through the cracks. You can't
Let me
always
just ask you
foresee
this:
it.
was C2 enacted at the same time as C1?
Yes, it was.
So they're not
why couldn't
separate.
The broadening relate to other ways in which one might prevent a proceeding from accessing information.
I kind of like
one is
Justice
documents,
Jackson right
records, and
now.
other objects, but the known unknown, we don't know, could it be intangible, for example, that C2 is sort of getting at when one gets at physical objects? I guess I'm struggling with leaping from what's happening in one in the context in which it was
To a
actually
dragnet
enacted, to
catch-all
all of
into.
obstruction in any form.
So I think the reason why we wouldn't suggest that the context could bear that narrower reading is because of the actual language that Congress used. If it was really just worried about other kinds of record-based, proceeding-based, evidence-based ways of obstructing, then there were easy templates to add that in as a residual clause to C1. There was no need to have this entirely separately numbered prohibition, and especially there was no need to use the well-recognized verb phrase obstructs, influences, or impedes, which was clearly drawn from these other omnibus clauses that sweep more broadly. So I think we think that it's perfectly consistent with the statutory history here to recognize that after Enron, what Congress thought is, we don't want novel ways that we aren't thinking about of obstructing a
Exactly,
proceeding
but
to
that's
not be a
why
crime.
two
We
fits
do
into
want to cover
one.
the waterfront of obstructive conduct.
She just made
with
the best
backstop
argument
of a
here.
corruptly mens rea, the limitation to an official proceeding, and so forth. And that's exactly what the words of the statute say.
Thank you.
Thank you, counsel. Rebuttal, Mr. Green?
Nope.
Justice Sotomayor, a defendant who tips off a grand jury witness or tips off the targets of a search warrant is someone who is certainly attempting to impair the integrity or the availability of evidence and would be covered by C2. Just as somebody who creates a document and then that document is shown to counsel and counsel withdraws a mandamus petition has in fact created something that has caused an interference with an official proceeding.
Yeah.
I heard my friend say twice in response to your questions, Justice Gorsuch and Justice Barrett, that C2 would cover peaceful protests as long as she could demonstrate, or the government could demonstrate, that there was the adequate mens rea and a nexus. As to nexus, let's look at what 1512F says. For the purposes of this section, an official proceeding need not be pending or about to be instituted at the time of the offense. There is no nexus. Congress has written it out of the statute right there. If the J6 defendants came on January 5th and did all the kinds of things that they did, maybe one would hope, but if it had happened that way, it would still be a C2 violation. With respect to the corruptly mens rea, Justice Kavanaugh, you asked a question yesterday about the fact that mens rea as a break only works at trial because the government's allegations are taken as true at the motion to dismiss stage. And I think that's exactly right. And that's why it's not a break at all. Or if it's any kind of break, it's a break on a go-kart. It's a wooden stick. What it means is that people like Mr. Fisher have to sit and go to trial and seek to win on a Rule 29 motion because the government hasn't proved their mens rea. The same is true of First Amendment defenses if peaceful protesters are charged with C2. My friend referred to 1503 and 1505, other statutes within, and a number of the justices have pointed out that there are much lower penalties for significant crimes. I would point the court to 1752, which is civil disobedience in a restricted space, which is what Mr. Fisher is charged with. That's a misdemeanor. If you cause substantial bodily injury, that is a 10-year maximum penalty. The government wants to unleash a 20-year maximum penalty on potential peaceful protests. That in and of itself is a bad idea because it's going to chill protected activity.
This is a
People are
finally
gonna
made a
worry
good
about
argument.
the kinds of protests they engage in, even if they're peaceful, because the government has this weapon. Finally, I think we haven't touched very much on the breadth of influence because that's one of the words that's used in C12. And that would not only would it be peaceful protest, it could be advocacy, it could be all kinds of lobbying. Those things would be covered as well, we've pointed out in our briefs. Then finally, I would say to the court, let's not forget that civil proceedings are covered here. We would submit civil evidentiary proceedings, but civil proceedings. So the government is suggesting that the court should unleash a 20-year maximum obstruction statute.
Oh, it's only a maximum. It's not,
on
they don't have to do that.
civil litigation in federal courts. I submit that is, and we would submit that is a
Excessive.
very serious tool to put in the hands of prosecutors.
Oh, she'd agree with you.
We urge
Sure.
that the court reverse the DC Circuit.
Thank you, counsel. The case is submitted.
Well, that's it for now.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
10 o'clock. Okay, I got lots to say, and I want to see the number go up now that we can actually talk freely. over this. That was interesting. That was boring, painful, and uninspiring. It's actually kind of depressing. Let me just get my, let's start from the very beginning here. The lawyer, I'm not going to make fun of her accent because she's from Boise, Idaho. And so she raised good arguments, and we might be picking on her because we do not like the fact that she raised good arguments, but she's got the easiest argument of the bunch. That's what the law says, eh? So Solicitor General, it is Solicitor General Elizabeth B. Prelogar. Let's see, Prelogar, 48th Attorney General. Yeah. I think she's 1 year younger than me. Solicitor General previously served multiple roles in Department of Justice. Before her confirmation as Solicitor General, she served as acting Solicitor General, yada, 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 for nearly 7 months. She also served as assistant, whatever, yada, yada. Okay, fine. Graduating from law school. Where does she go to law school? Solicitor General was born and raised in Boise, Idaho. That's where Napoleon Dynamite was filmed, I think, eh? And that's Minnesota, Fargo. Graduated in the area's public schools. She received her bachelor's degree, summa cum laude, from Emory University, master's degree in creative writing, with a distinction from the University of Andrews. Yada, yada. She went to St. Petersburg, Russia. She's a commie. At Fulbright, she graduated magna cum laude from Harvard Law School. Well, now we know that she's a problem. All right. So that's the prosecutor or the Solicitor General. And Wikipedia. Just want to bring this one up because it's fun when you zoom all the way into the eyes. She looks like my someone I know, actually. And yeah, so that's the lawyer. I'm not going to make fun of the accent because it's Boise, Idaho, and it's not fun to make fun of people's accents, if they come from Canada. But some of the frustration might be that she made, I think she had a better presentation than Fisher's lawyer, personally and honestly. I initially was going to make the prediction that, of course, the court is going to strike this down. I even think Ketanji Brown Jackson is on the side of Fisher here. But what you could clearly tell is that she was just like, just assure me that you're never going to use this against Black Lives Matter. Just assure me that you're never going to use this against progressive not anti-trans, but rather trans supporting protests. Just assure me that you're not going to use it against the people that protested Kavanaugh and only against the far right MAGA extremist Republicans who are, insurrectionists. And look, other than the discretion, that's what Ketanji Brown Jackson's concerns are, in my view. We were talking a lot of the C1 and the C2, and nobody who hadn't read this piece of legislation knew what the hell they were talking about. Here, this is the provision, the code, United States Code 18, Section 1512, tampering with witness, victim, or informant. I will preface this, everybody, by saying I am now a former practicing attorney from Quebec, never did criminal law. I have no expertise in this, and you take my analysis and my thoughts and my queries with a grain of salt, as you should. I pick the brains of people who have bigger legal minds than me. I absorb their information, and it becomes mine. They can never take it back. So take that what I'm about to say with a grain of salt, because I read this and I try to make sense of it at the same time. You're in a section that deals with tampering with a witness, victim, or informant. Whoever kills or attempts to kill another person. 1. Whoever uses physical force, threat of physical force against any other person. 2. The punishment for the offense. 3. Now we go down. Whoever knowingly uses intimidation, threatens, corruptly persuades another person, yada, yada, yada. Okay, now we keep going down. Influence or delay the testimony. Cause, induce person. Now we're in this. Hinder, delay, prevent communication of law enforcement or officer. So you got a whole slew of these things here. Deals with violence, witness intimidation. Now, because of the Enron edition, destruction of documents. C, and it has 2 parts, 1 and 2. C, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs. So they can do it this way or in any other way, obstructs, influences, or impedes any official proceeding or attempts to do so. So the question is, they kept on saying, well, what's included in 1 that's not included in 2? 1 says alters, destroys, mutilates, or conceals a document. And then 2 says otherwise obstructs. So do you read 2 in conjunction with 1 or as a standalone in addition to 1? And that's the argument. My argument that I've been screaming out loud that I wish they could have heard, if 2 is a standalone and it's not to be read in addition to 1 and thus complementary to it, 2 includes 1. Any obstruction, influence, or impede any official proceedings includes altering, destroying, mutilating necessarily. So if 2 was not intended to be read as complementary to 1, how can it add what might be missing from 1 without just being a standalone catch-all or dragnet, as they said? I forgot the way I was going to finish that sentence. If 2 was intended to be a dragnet catch-all, why even include 1? That's my argument. It's quite clear. You have alter, destroy, mutilates, or conceals. Now, hypothetically, you get to the year 2024, where you can have AI-generated fake testimony. That's not altering. That's not destroying. That's not mutilating. That's not concealing. But it sure as hell is otherwise obstructing or influencing if you create fake testimony in ways that were not contemplated at the time. Or you say, look, I don't want some witty, snark-ass criminal saying, I didn't alter, destroy, mutilate, or conceal a record, but I sure as hell did what I wanted to do in terms of obstructing or influencing or impeding any official proceeding in a way that wasn't captured in alter, destroy, mutilates. And so they said, well, we don't want some smart-ass criminal weaseling out of responsibility by saying we didn't enumerate it in 1, so we're going to complement what we said in 1 with or otherwise obstructs, always to be read in conjunction with 1. That's the argument. Then you have some other more complex arguments where they're referencing other provisions of law that we're not going to get into. That's the argument. And what you have, what was her name again? Prologar saying, well, no. You see, 2 is totally standalone, totally independent, and is much broader than 1. I mean, basically, because it's not, they're talking catch-all versus dragnet. And I like that analogy. They should have harped on that as well. A catch-all is to say something that we might have missed. A dragnet is to say we're scooping up everything, even if it wasn't the intended target. And they did not look at it's easy to say sitting from here. I sure as hell have never been to the Supreme Court of the United States of America. It's very easy to calmly listen to the question and say, oh, that's what they're asking. That's what you need to get at here. I think the Solicitor General did a better job. It sounded like the court was almost amenable to her, but they started getting a little bit harder on her towards the end, because the bottom line, any protest, and I wouldn't just say any protest, I would have said this as well. Every protest is intended to do exactly what Section 2 criminalizes. Oh, why didn't they say that? They're like, oh, well, isn't there a risk that this would capture, ordinary protests? Oh, if I'm Fisher's attorney, not only is there a risk, that's the necessity. Every protest is intended to some extent to frustrate, impede, or otherwise. That's the nature of protest. The more disruptive it is, the better the protest, to the extent it operates within the confines of the law. The problem with this subsection 2 is it effectively, if given the interpretation that Prologar wants to give it, criminalizes protest, period. Sitting out on the front lawns of Parliament. Oh, the chanting. The chanting is impeding. The chanting is making it hard for parliamentarians to get into the building. Oh, here. Well, no, because you see, now Hillary corruptly destroyed documents and delayed a hampered investigation. Well, yes, but I mean meaningfully so, because what did Hillary do? She altered, destroyed, mutilated, or concealed record or document or other attempts to do so with the intent to impair the object's integrity or availability for use in official proceedings. She obviously did that. Smashed it with a hammer and wiped it with bleach bit. So the thing about, be careful about these, I say they're whataboutisms, but they're not, these comparisons, because what Hillary did was actual obstruction. What these January 6ers did was not. Even if it was assaulting a police officer, slap on 20 years. It's an amazing thing that this provision can enhance otherwise other crimes or alleged crimes that had a lesser infraction that were more serious. Just slap it on. If you assaulted a police officer, obviously it was to obstruct the proceedings. Oh, no, don't worry, because we do the analysis, right? We say, did he punch the officer in the face to prevent the vote count of the electors? Oh, no, he didn't. Then we won't charge him with this one, which carries a greater sentence than the actual assault. Oh, trust us. Oh, I'm sorry. You think they won't slap this on to every single charge that they plausibly can? Was that the intent of this provision when they enacted it? The answer is obviously no. Now, again, much easier for me to sit here and say that this was an Enron level, Enron era amendment. And no, it wasn't two separate and distinct amendments. It was part and parcel of the same add-on. We don't want people weaseling out the way they did out of Enron. Section 2 is not independent and distinct from Section 1. They were part and parcel of the Enron amendments. Is that what they were contemplating when they did it? Hell no. Is there a risk that it's going to be broadly abused to criminalize all disfavorable protest? Hell yes. That's my analysis. But it's easy to say. And I might just be totally wrong. There might be, Lawrence Tribe might be watching and saying, that stupid Canuck is saying the most legally untenable things on earth. Bottom line, I don't think I am. But it's not a legal opinion. That's just my analysis. So the next time you are somewhere protesting and some cop invites, open the doors for you to come in. Start walking the opposite direction, says Coder 182 from Rumble. They should have been doing that from the beginning, by the way. But okay, so hold on. We got some stuff here to address. What about FBI lawyer who changed email from yes to no? Kevin Kleinsmith, 15. Oh, no. But he didn't do that to corrupt. Oh, for sure he did. Kevin Kleinsmith, nobody on this channel who's been here for any extended period of time is unfamiliar with Kevin Kleinsmith. I keep saying David Kleinfeld, the lawyer from Carlito's Way. Kleinsmith modified an email to which he was neither a sender nor a recipient to physically, materially alter the email, printed it up, said that Carter Page was not an asset when Carter Page was an asset, which explains why he had interactions with Russians. If he's an FBI, CIA asset and he's interacting with Russians, obviously it makes sense because that's what they do. If you, as Kleinsmith did, edit, alter an email that you're not a party to, submit it to a FISA court judge. So the FISA court judge says, oh, he was in touch with Russians and he wasn't a CIA asset. That's suspicious. Everybody knew it. What did he get? No jail time. He had a kid. He got disbarred for a year. I think he's actually been rebarred or readmitted to the bar. So yeah, absolutely. You're right. Penny G. Viva, the government's lawyer, has a really good argument. I hate to say it, but it's fact. She has the easiest argument. That's what the law says. It says otherwise. I mean, if they wanted to limit it, I mean, the bottom line, her strongest argument is if they wanted to if they wanted to limit, what the hell's my problem? If they wanted to limit subsection 2 to the parameters of subsection 1, they would have just written subsection 1 as alters, destroys, mutilates, ... for use in any official proceeding, comma, or otherwise obstructs, influences, or impedes. If they wanted it to be part and parcel of the same, clearly and unequivocally, put it in the same provision. The fact that they broke it down into two separate provisions, I'm just going to go with the plain reading, Otherwise obstructs, impedes, or influences. Nothing in subsection 2 talks about documents, evidence, or witnesses. So that would have been her strongest argument. If they wanted them to be read together, they would have drafted them together. Bottom line, I don't care how they drafted it, separate or together. This goes too far as drafted. Void for vagueness. I don't know what other statutory canons of interpretation there could be here. Void for vagueness, or in even reading it in the context of the time, it was never intended to apply as it's currently being applied right now. Because otherwise, it effectively, unequivocally, and categorically criminalizes protected speech, protected protest, protected rights of association, and a number of other constitutional rights, which don't seem to mean all that much these days, neither in the States nor in Canada. I wish you lived near me in Central Florida. My daughter is a fantastic dog groomer and works well with special needs dogs. Where's Winston? They trimmed, we won't be having any wheel nuts on Winston for a little while. The groomer trimmed very close to where those little nuggets of poo-poo get caught in the hair. He smells delicious. I don't want the dog's hair to be too short. I like a raggedy dog, but it comes with problems. You will have to remove my meme from my cold, dead hands. I'm keeping this up because I'm actually going to steal that and make a meme out of that, or at least maybe ask Finboy Slick in our locals community to do that. And there's going to be some Rumble rants in a second. Viva Frei, is the vocal fry getting to you too? Yes. And it's I don't like vocal fry, and I find it annoying across the spectrum. I try to make sure not to have vocal fry, but every now and again when I want to sound more intelligent, I let my vocal fry fly. Viva, I think the court is aiming at it's either all X or only those in C1. What do you think? I'm not optimistic. I think they're going to. Let me think about what my prediction is going to be before I get there. She's already planning on selective enforcement, Joanon. That's the other thing that I picked up. Like, yeah, absolutely. Just reassure us you're only going to do this when it's warranted. Hillary Clinton smashy. Oh, no. Go through a door. Yes. Extreme MAGA Republican. Yes. Lefty progressive. No. Black Lives Matter. That would be racist application of the law. Stop the steal. Ooh, interfering with progress, Congress, whatever. You know what I mean. Okay, hold on. I want to bring this up. Ooh, Biltong is in the house. Biltong, the latest shipment came in. It's delicious. Hold on. Oh, yeah. Hold on. Oh, gosh. Well, it seems Pudge was whining to get out of my office so that she would spare me the duty, the glory of her taking a dump on the floor. I went outside. There's a little nugget on the ground, but I didn't step in it. Thank goodness. Hold on. Let me just bring this out here. This is my recent order. Shipment of Biltong. I just want everybody to see what this looks like. This is not an ad, by the way. I'm not clicking the sponsored box because this is not a sponsored video. I'm just eating this. This is the Wagyu. Look at it. Hold on. Focus. That's the Biltong, people. I hate eating on camera. It's softer than beef jerky. It's like eating, basically, if you've ever left a steak out overnight and then eaten it the next day, which I've done many times, that's close to what this tastes like. Hold on. I hate eating on camera because nobody likes the sounds of someone's chewing, potching mouth. This is not yet ASMR, but let me read the rumble rants that came in. King of Biltong, good afternoon from Anton's in Roanoke. Meet and eat. Free shipping for your Biltong using code VIVA. This is a $30 rumble rant on www.biltongusa.com, antonusa.com. Biltong, a dragnet for all your taste buds. It's objectively delicious. Unless you don't like meat, in which case you are objectively crazy. UACP 17. She's saying, please give the government massive protest crackdown power, and I pinky promise to use prosecutorial discretion fairly. Hard pass, they're abusing it already. That's the thing is, like, if that lawyer were watching this live stream as he was talking, as they were pleading, that's an argument right there. Oh, yeah, just trust them. They're only going to use it where the mens rea of the corrupt intent to interfere with a criminal proceeding. Bullshit. First of all, I want everybody to understand this. Again, this is not legal advice, period. People think the mens rea. So you have actus reus, mens rea, both elements of a criminal conduct that need to be proven beyond a reasonable doubt in order for there to be a conviction. Proof that you did the act, actus reus, and proof that you had the intent not to break the law, but to do the act that was illegal. Mens rea. And remember, people think like, oh, I didn't mean to break the law. Ignorance of the law. It's like, oh, well, did you mean to go 100 miles an hour? Yes. Did you know 100 miles an hour was illegal? Doesn't matter. Did you mean to do the act that was prohibited under the law? Not did you mean to break the law? So this was going to say, oh yeah, it only requires the mens rea of the corrupt intent to interfere with an official proceeding. How do you corrupt intent? Well, that requires a little bit of mind reading, or a little bit of just let's go to trial and see if the person presents a what's the word I'm looking for? Beyond a reasonable doubt as relates to that element of the infraction. So there is no stopping where this would go, and they should have highlighted that. Oh, I'm sorry. You want them to be able to prosecute anybody who they allege corruptly intended to impede an official proceeding. Oh. double park your car behind a police officer. You corruptly, I mean, I'll take some absurd examples, but let's start with the reductio ad absurdum to illustrate why this cannot stand as a rule. So you're 1,000% right. UAC, PA, you know who I'm talking about. Abraham P. logged out of locals and back in, still seeing nothing, but I feel it's probably on my end. No, locals good. I'm going to get there in a second and interact with the chat over there. Let's just finish this up here. Excuse me. How do these okay, we got Crash Bandit says, how do these actions from our government not make people crazy, or is this how the FBI performs a nudge? Yes. Is the local stream, it's not loading refreshing? Lisa is there. Okay, we got that. Now, so that's that. I'll get here. Locals. Let's see what's going on here. We got a tip in locals. It says, finally got locals to load after some effort, says Abraham P. Yeah, it's things. Finboy Slick says, we're good over here. Finboy Slick is the master of memes or AI generated images and wants me to not grow a mullet, but cut my hair in a manner such that it would result in a mullet. Not gonna happen. By the way, stay tuned later this afternoon. I'm not sure if I'm going to do it live because it might just be a 20-30 minute interview, but a follow-up with Dexter Taylor, ghost gun guy who's now entering closing arguments in his criminal defense, in his criminal trial. He could, in theory, be hauled off to jail tonight. So they are doing closing arguments. I presume there's going to be more than 30 minutes of deliberation. So I'm going to see when he's available. We're going to record a follow-up of his trial, and I'll publish it regardless of what happens. S_Ren says, Viva, it's absurd until Alex Jones becomes the first, not the only person charged with stupid things. Absolutely. I'm trying to think of who they targeted like this before Alex Jones. But I think Barnes is right. Like they did this type of stuff to not politically disfavored. That's what they're doing now. They did this to like people with no voices. And so it's been going on for years. And, you meet the guy who says, like, I've been prosecuted by the FBI and all this crap. And you're like, yeah, I never heard of it. Of course he didn't, because I'm not the president. I'm not Alex Jones with millions of followers to put it on blast. And they were smart enough to do it to people who couldn't speak out, fight back, or protest. So there's that. What was I going to say also? Oh, yeah, hold on a second. We're on YouTube. We have YouTube. Did I close it? No, we got 2,500 people on YouTube. If you're so inclined, hit the thumbs up and subscribe. But more important than that, come over to Rumble and vote with your dollar and your eyeballs and your feet. Rumble. On Rumble, how many are we? 6,100. Subscribe, give a thumbs up. Have we ever gotten to like a number of viewers thumbs up? Hit thumbs up and let's just see what we're up to 670. That's 10%. That's not bad. Okay, that's fine. Viva. They also went after Rush Limbaugh. YouTube is still a thing. Jacob Castro. YouTube is like an advertising tool for Rumble in all respects. Let me see what we got here. Smash that like, bigots, says Jacob Castro. So, so we did this. This was interesting. Okay, so the notes I took. Let me just see here. From catch-all to dragnet, I like it. Justice Thomas was focusing on the otherwise. What does that word mean if it's not to be read in conjunction with paragraph 1? Oh, I don't want to judge the lawyer too harshly. There could have been better arguments. And who asked, had C2 and C1 been drafted together, what then? That's the question I had. Then they got overbreadth, overbroad versus misapplied is one of my concerns. A little piece of confounding two arguments. Okay, so why even put C1 in if C2 is a catch-all? That was my notes. C2 being the otherwise captures everything. Well, okay, we want to be specific to documents, and then we want to be general to everything under the sun. Okay, that's it. Oh, then the heckler. Well, did the heckler mean to meaningfully impede? Meaningfully impede. All right, I think that's it. And then we didn't talk about Owen Schroyer. They didn't get him on that charge, but why not? Yeah, he protested while Penguin Nadler was talking, and lock him up for 20 years. Oh, but don't worry, that's just the maximum. There's no minimum. I'm sorry. The fact that it's a maximum of 20 years is intended to indicate the seriousness of the crime, not the arbitrary. Just make every crime a maximum 100 years, maximum life, but no minimum, and then say, well, no biggie, just maximum life. Oh, I think we did good here. Let's see here. Go back to Make a damn Rumble stock go up. It would be nice, says RP McMurphy. What is the Donald Trump at these days? RP McMurphy says your hair finally looks good. It takes a long damn time. Nobody cares about my hair, but there's that magic window. The day you wash it, brush it, and oil it, it doesn't look good. And then if you put it in a ponytail, as my daughter now has told me, if you put your hair in a ponytail when it's wet, it dries straight, not curly. So like after 2 or 3 days, it gets good. Then it gets greasy, knotted, and then rinse, wash, and repeat. People, unless I've missed anything, I'm going to go to the chat and see if I've missed anything. This is Rumble streams too rich on live streams. Rumble streams too rich on live streams. Oh, I see what you're saying. So Garrett Pace is saying, oh, I can bring it up. Why am I not doing this? Rumble streams are too rich on live streams. Fix it. As in, no, I think that's the feature of Rumble, not the bug. YouTube is a social media platform. Rumble is a network. And I don't mean a network like networking, synergizing. People go to Rumble for long format, informational, educational material. People go to YouTube for kitty cat videos. There's nothing wrong with that, and there's some kitty cat videos on Rumble. But I think Rumble is sort of like better than, but a Spotify. People go there for the network of information providers that they like, and they don't go there to for like freaking TikTok videos. So, what are cruise braids? Are those cornrows? Jerry Curl Viva. So close. Oh, yeah. Okay. So that's look, we did this. This was fun. What else is going on? So tomorrow I'm going to be on The Unusual Suspects, but I'll probably go live as well because it's an early day, so I can get a stream in the afternoon. Friday, Jason Palmer, not vice president, running for president against Joe Biden. It's going to be fantastic. I think we are scheduled from. Hold on. Let me see. It's in my calendar. 1 to 2. Booyah. It's going to be fantastic. And what else is there? Locals? Well, no. I'm gonna end this on both Rumble and YouTube. Come over to Locals, and we're gonna have our after party. I don't know how long it's gonna last, but I'm gonna eat during the after party because I'm hungry. I haven't eaten breakfast yet. Link to Locals. Come on, boys. We had a good one last night after the stream. I got to upload yesterday's stream. I got to upload the audio, and I'm going to go do another video, catch up on Trump trial. Have there been any news there? We'll find out in our Locals community. So thank you all for being here. Viva Frei, David Freiheit, Montreal litigator turned former Montreal litigator. And Freiheit, it means the freedom, yeah. Like dreadlocks. Oh no, I'm not doing dreadlocks. I did dreadlocks once, cut my hair the day before I met Marion for the first time in 1999. Rumble is floating at just over $6. It never does anything. Long run, think Bitcoin, but maybe actually tangible and something that you know how it works and what it does. Rockstar, thanks, V's. Nice to see you again, Rockstar. Wait, but there's 2 Rockstars. There was one that had the turkey, the wild turkey in the avatar. Do you need the cow poop in your hair? There will be no cow poop. You will eat the cow poop. And make sure I didn't miss anything before we head out and check out for the day to the Rumble after party. Okay, we're good. So here's what we're doing. I'm ending it. I will see you all tomorrow, probably this afternoon with a short car vlog. Although I think I'm going to do the car vlog in the office because the wind drives me crazy. Thank you all for being here. I hope you enjoyed. My prediction. I don't think they're going to overturn it. And the problem is now I'm saying that knowing that my predictions tend to be wrong because that's what I want to be the case. So now I'm using like double reverse psychology. If they said the obstruction cannot be read the way the prosecution wants, it would be good for Trump. I didn't get that impression, and I hope to be wrong, but I do not think they're going to invalidate the obstruction charge. That's my prediction, and I hope I'm wrong. With that said, everybody, go and enjoy the day. There's much time left. Sunlight, exercise, talk to people in real life. Ending on YouTube, 3, 2, 1.